Can I just say something about Andrea?
Hey guys, welcome back for a little more discussion and review of what's going on in the case against Luigi Mangione. If you joined me for the first look at this case when we went over some of the documents that establish probable cause, you'll remember that kind of what the issue in the case was at that point in time was that this is one of those situations where the identification of the suspect is very rapidly followed by that suspect's arrest. And so because probable cause is what you have to file to basically justify your arrest, it means that often in that situation, the information and the evidence that is available is kind of preliminary. Like it's enough to get you over that hurdle to arrest, but it may not be what you need in order to get a conviction beyond a reasonable doubt. So there's a lot of investigation in those types of cases that only takes place after the arrest. They have to, go through and do a whole bunch of like background, look through financials, look through communications, look through all these different sources of information that if they had a perpetrator identified ahead of time, they might have done that before the arrest. But so it's just kind of a factor of timing that relates to, just when things are developed over the course of a case. So we looked at the probable cause, and what we saw was that there seems to be a very strong link between Luigi Mangione and this individual, Mark Rosario, who checked into the hostel in Upper West Side, I think, of New York City. And that is largely substantiated by Luigi at the time of his first contact by law enforcement, providing the same Mark Rosario, New Jersey driver's license as his form of identification. Person who checked into the hostel used the same New Jersey driver's license with the name Mark Rosario. So they have a fairly strong link there. Where the link is maybe not quite as strong at the time of probable cause is the link between that person, Mark Rosario, who checked into the hostel on November 28th or 29th, something like that. 24th. Now I don't even remember offhand. Anyway, like 10 days before the shooting. And then the person who on December the 4th was in Midtown Manhattan, on video doing the shooting and so forth. So the basis for that connection was, well, we tracked him on video throughout the town. We were able to watch his movements, so we know it's the same person. He was in distinctive clothing. But then when we kind of get into the details, it's like, well, but it doesn't sound like you have, continuous like coverage of him. He's not like in sight on video the entire time. His clothing is really not particularly distinctive. We can see it for ourselves on the surveillance video. It's like a dark hoodie and dark pants and those John O'Keefe shoes, right? The dark shoes with the white soles on them. So, not, I guess, entirely out of the range of possibility that, we either have maybe different people involved or like, how did we even identify the person coming out of the hostel as the Mark Rosario, character in the first place? So that's just the weaker part of the link. A little bit strengthened by, the arrest. And again, at the time of the arrest, Luigi was in possession of a backpack that police searched. In the backpack, they found both a firearm with a silencer, which is consistent with Mr. Thompson being killed by a gunman who had a handgun with a silencer on it. And then also some writings, some notebooks. There's the FBI letter, the Fed letter, they call it, all of which contained like some statements incriminating descriptions of motive and things like that. So we've got a couple of different things going on that we're going to be looking at today. So today we're like jumping way ahead in the case from the point of probable cause and the point of arrest back in December of 2004 to now investigation has occurred, post-arrest investigation has occurred, discovery has been produced. So we're going to start by looking at that. We're going to look at the state's discovery notice in the state case, the New York State prosecution against Luigi, to see what exactly it is that that prosecutors, were able to develop and hand over to the defense. And that'll give us a little bit of perspective on the strength of that post-arrest investigation. But then we're also going to turn to what I'm sort of shorthanding as motions to suppress. There's more to them than that. This is a defense motion that was filed in state court back in beginning of May of this year. And it's an omnibus motion, which means it's a motion that contains a lot of motions in it. So it actually raises a lot of things, and some of those have already been decided. This is the motion that raised, for example, the challenge to the use of the terrorism statute for the crime. The defense argued that even if you take these facts as alleged, they don't constitute terrorism the way that New York defines that particular crime. That's already been decided. The court agreed with Luigi's argument on that throughout the terrorism charges. So now he is facing murder in the second degree as the most serious charge, which is still an intentional killing in New York. It just doesn't have that kind of aggravating factor of being a terrorism that elevates it to murder in the first degree. He also argued that there was a double jeopardy problem with prosecuting him simultaneously in state court and federal court, which is still going on. The court rejected that argument, basically said, we haven't seen that there's enough of a problem here of like needing to present inconsistent defenses or something like that, given the nature of the allegations. So we think you can adequately defend yourself in both cases, even if they're going on at the same time. So those two parts of the motions have been addressed. But what's outstanding are a motion to suppress statements that Luigi made at the time of his arrest, arguing that he was not read his Miranda rights and that they were required under the circumstances. He's also moved to suppress the evidence they found in the backpack as the result of that search when they first contacted him in the McDonald's in Altoona, Pennsylvania. They, developed their suspicion. They detained him. They questioned him, and like at some point in this process, they decided to start going through his backpack. They don't have a warrant. So we talked about this a little bit last time too, kind of what the rules are and where some of the exceptions are. Fourth Amendment has been like ratcheted so far down in terms of the actual protection that it gives you, that whether, not having a warrant matters at all, it can depend on, a lot of different factors. And so this motion's looking at what the circumstances were, what the proposed justifications were from law enforcement, and whether it satisfies those requirements. So it's a very important motion, of course, because if it's granted, then that's essentially saying what you found in the backpack is fruit of the poisonous tree. You can't use it to prosecute Luigi. It would have to be suppressed. And without that evidence, you might have a little bit of a problem proceeding. We'll talk about kind of what the potential consequences of that might be and how far that might go. And then the last thing that is going to be on the table here is just a motion that the defense has filed to argue that for non-expert witnesses, lay witnesses who are going to try to identify Luigi as the person they saw in the video, there's a specific test that you have to go through in New York to kind of establish a foundation for that type of evidence. So that's also on the table. That one is kind of, I don't know, a little bit less interesting, really, from a significant standpoint, because it's not going to ultimately end up being the most important evidence in the case either way. But just, we're going to see it. It's in the paperwork. So just full disclosure that's going to be there. So the real focus here today is going to be on these two primary motions, the statements that he made to police and the evidence that was obtained in the course of the arrest. So let's start by pulling up this discovery notice that the state filed. And so this, I gotta say, I haven't seen a lot of New York State cases. Don't think I've ever looked at the automatic discovery form before, but it's very extensive. They provide a lot more information about what they have, what's disclosed, what it consists of, the factual bases for the case, and so forth. Than a lot of similar types of documents that that I often see. So it gives us a lot of these details. This is the crime. We know that. This is when he was arrested. This is when the seizure of him and his property took place, December the 9th in Pennsylvania. So five days later. And then he was formally arrested by New York on December the 19th after he was extradited from the state of Pennsylvania. So just those specific dates in question. They have statements that they intend to offer from Luigi. We know about the ones that they have described taking place at the time of the arrest, like leading up to the arrest. There's not really been much indication that they intend to use other types of statements, but there may be some. Just that remains to be seen. They are going to offer identification testimony. Again, don't necessarily know who, if it's going to be from somebody who's looking at the videos and saying, I recognize that it's as him. Maybe, the clerk who checked him in at the hostel, somebody like that could say, yeah, that's the person I checked in. So those things would all potentially be discovered under that. Documentary evidence. They're going to use witness statements. That's pretty normal. They're going to use photographs and drawings. That's also pretty normal. Now, here's where it starts to get interesting. Scientific and medical reports that they have. So here's what they intend to offer. Ballistics reports disclosed. So they got some. They went and did some testing on the firearm that they found in Luigi's possession, and they compared it to what they were able to recover from the scene. They may have bullet, that is suitable for comparison. They may have shell casings. They did talk about recovering shell casings that are suitable for comparison. So that has been done. That's one of those links that has the potential to close that gap between how certain are we that the Mark Rosario who checked into the hostel is the same person as Luigi Mangione, and they are both the same as the person who did the shooting. If the gun Luigi had in Pennsylvania is the gun that did the shooting, it's a stronger case. Medical records to be disclosed. These are likely the victim's medical records, but it's also possible that they have done investigation. In fact, we'll find out. We kind of already know. They have done some investigation into Luigi's medical background, so likely some of both of those involved. DNA reports have been disclosed. That's going to be real important, right? If they can show a DNA link, DNA high quality like PCR DNA results can be extremely specific, much more targeted than just the ballistics, which they will tell you like, oh, we can match this shell casing to this gun or whatever, but they really can't, like scientifically, they really can't. They can say it's consistent with the gun, but they can't say to the exclusion of every other gun in the universe, except in perhaps pretty rare circumstances. DNA can get you down really, really specific as far as the odds of that particular profile showing up at a crime scene. Toxicology is disclosed. That also is probably the victim. Autopsy is certainly the victim. Latent print comparison report disclosed. So they've looked for some fingerprints. You've looked for fingerprints. And then other NYPD laboratory reports. So this is a lot of forensic stuff that they've done. And that's really where, in my view, they have the biggest potential to close that circle between Mark Rosario, Luigi Mangione, and the person who committed the shooting. Search warrant materials have been disclosed. Electronic evidence. There's quite a lot of stuff here too. So police radio runs to be disclosed, the radio traffic, the information that they were receiving, how they reacted in response to it. Pretty normal, to have that will be disclosed. 911 calls, also pretty normal. Videotaped statement disclosed. Not entirely clear what that is. I suspect that this is referring to the fact that when Luigi was contacted in Pennsylvania and ultimately arrested, that was on body cam, and so he made statements while he was body cam on body cam. I think that's probably what it means, but I'm not 100% sure about that. Surveillance video has been partially disclosed. We already know that's how they did their investigation. They did the video canvas, found all of the images that they were able to piece together to track the trail of the person that they believe did the shooting. And then the body-worn camera video, again, that's from the Pennsylvania approach. Now, additional electronic information. This is a lot of stuff that they've gone into that background information. So they've got his phone records, they've got his bank records, they've got his iCloud. Okay, your iCloud is like a lot. There's a lot there that's going to have, potentially his internet searches, his writings, his documents, his communications, just a massive amount of stuff that's going to go to planning and preparation. It's going to go to motive, potentially. Might go to, means like this was, for example, a 3D printed gun. Maybe we're going to have, the plans, the CAD plans or something for the gun. Just a massive amount of stuff on an iCloud account. iCloud records associated with his laptop. I don't know if that's different. Maybe it's in a different iCloud account. Data from the following devices owned and or accessed by the defendant. So we heard about this first one. They found a cell phone at the scene. And that was all that we really knew about it. We knew that that was going to be, again, a potential link because they're going to be able to get into it, extract it, see what, if any, information they can find out about who had possession and control over this particular cell phone. And also maybe just whether it, because I don't think they said, like, nobody saw him drop it. So just establishing that this is in fact associated with the crime at all. They might be able to track the phone's location and see if it, follows the trail of the individual who committed the shooting. But then they've also got an iPhone that was recovered from him. This is, again, presumably when he was arrested. The rest of this stuff, an Apple MacBook recovered from him. An HP laptop believed to be used by defendant at Altoona Best Buy. That's some new information. He went to the Altoona Best Buy and maybe used this HP laptop. Not entirely sure what that's relevant for unless he used it to, for example, search or communicate or something like that. Something that would be relevant to proving the crime. They also haven't told us what their basis is for thinking that he is the person using the laptop. Don't know. Is it entirely contextual? Do they have him on video? Did they trace his location? They haven't said that, but we would expect that they would be able to do at least some of those things. Another HP laptop believed to be used by him at the Best Buy. Flash memory device, a couple of them, few of them, 4 of them. And again, all of these likely recovered from him at the time of his arrest. So then what we have here is essentially a long listing of the actual physical evidence, the physical items that they either recovered or they created over the course of doing their forensic analysis. So we've got the live cartridges found on the front of the Avenue of the Americas. So somehow these cartridges got dropped and were left there at the crime scene. A clear ethos bottle, a water bottle, and a multicolored kind bar wrapper that were found in the trash can. a kind granola bar that was discovered in the backpack. Remember, the shooter had this gray backpack on that was somewhat distinctive, like much more than the clothing. I think it had a fairly recognizable shape to it. I was kind of curious about, like, okay, he gone into the park with the backpack, right? Rode the bike into Central Park with the backpack. They lose sight of him. Then he's coming out of the Central Park and he doesn't have the backpack anymore. And then the backpack is found in what looks to be a fairly remote area of the park several days later. And it was kind of a curious fact because, why did you even have the backpack if, you didn't need it to, like, hold the gun and hold your notebooks and the things that you were later found with in Pennsylvania, if you're the shooter. Because he never went back to the hostel. The shooter went from the crime scene and took a path through Central Park ultimately, and then, got in a taxi and ultimately ended up getting on a bus. It looks like getting in a bus station and fleeing. So there was never any, like, I went back, maybe I stashed stuff at the hostel and went back and collected it, before I left. Nothing like that. So this granola, this backpack was kind of I don't know, it's a little bit of an open question about what it is. And one of the suggestions had been the counter surveillance. There was, like, a reference in one of the documents to he engaged in this counter surveillance type of activity. And so if that's the case, then this is, basically made to just confuse the pursuit, either by, having it and then ditching it in the park, by making it look like it's associated with the crime when it's not, some sort of, like, plan to mislead investigators who were following up. So they found a granola bar in it. It's the same type of granola bar as the wrapper that was found in the trash can at the crime scene. Then the blue Motorola cell phone, the one that was left at the scene, some more shell casings, 3 of them that were found at the scene. The shell casings, not the live ammunition, are going to be the ones that are most likely used in the ballistics because they've been fired through the gun. So they're going to have the markings on them from all of the action of the gun to extract it from the magazine, load it into the chamber, and then be fired and ejected out of the firearm. 2 swabs of possible DNA from the premises. Don't know what that means. I would suggest it probably means blood. Probably means like some blood spatter, but they don't say that specifically. Swab taken from the edges of the kind bar wrapper recovered from the scene. So this is the one that was in the trash can. They swabbed it, and they swabbed it for DNA. They swabbed it for DNA. 3 swabs taken from the cartridges recovered from the scene. Again, this is going to be for DNA analysis. The backpack itself that was in Central Park. The black Tommy Hilfiger jacket was inside the backpack. There was Monopoly money inside the backpack. This is a weird one. I don't know why anybody would have Monopoly money in the backpack. It seems like that might relate to this counter surveillance type of allegation. But I just, I have a hard time imagining what purpose it serves. Maybe literally just to fill out the backpack. I really don't know. But hey, it's there. They have it. It's part of the evidence of the case. Swab of textured edges of waxy paper bag recovered from Central Park. So we don't know anything about this bag, as far as I know. Waxy paper bag. I don't recall this being discussed at all in the probable cause. It doesn't sound like this was in the backpack. This was recovered from the park. So we don't know much about it, but by swabbing it, we know they're looking for DNA. Same thing, swab from the edges of the wrapper recovered from the gray-brown backpack. So something inside the backpack. Swabs from the backpack itself. This is a lot of, looking for DNA in different places. 4 adhesive stubs taken from the hooded jacket recovered from Central Park. Okay, don't know anything about that or what that consists of either. Adhesive stubs. Adhesive stubs. This sounds like the kind of thing where I was just listening the other day to I've been trying to get catch up on Buried, the podcast that the Defense Diaries is doing on the Gacy case. I'm really enjoying it so far. I'm like, kind of rushing to catch up. So if those of you who have already been listening and are way ahead of me, you might have to think back to some of the earlier episodes. That's where I'm at. But they're talking about where I'm at right now, that inside the jacket that Kim Byers, who was a witness who placed Gacy inside this pharmacy where the last victim, Ronald Peace, was last seen. She had borrowed Ronald Peace's jacket and had put into, I think this is how it went, had put into the pocket the little like tear off paper that you used to get when you sent film in to be processed. When you took your film to the store and they were going to send it off, they have an envelope that they stick it in, and then they, tear off this receipt that they give to you so that, they have like the matching numbers and stuff like that. That's what this made me think of, is maybe something like that. Like it's some kind of a ticket that's got two sides. Maybe it's got matching numbers. But I don't know. Describing it as stubs makes it sound like it could be some kind of ticket like that. Maybe some kind of like a coat check, locker, something like that. Maybe when you check a bag on a train or on a bus, something, certainly on a plane. That's what it sounds like. But again, don't know. This is all we really know about it. 2 tapes taken from the hooded jacket. Don't know anything about what those are. Multicolored paper fold containing wad of possibly chewed gum collected from outer side pocket of gray-brown backpack. This is a little bit of a weird one because it sounds like what they're saying is somebody chewed some gum and put it in a wrapper and wrapped it up and stuck it in the side of the backpack rather than throwing it in the trash. So this sounds, again, like one of these kind of counter surveillance things, right? That they might be able to track your DNA from your gum. So you deliberately don't put it in the trash. You keep it with you. But then it would be quite a big mistake to leave it in this other item, right? This other like counterintelligence, counter surveillance type of item. So I don't know what the explanation for this is potentially going to be. Yeah, really don't know. The New Jersey driver's license, Metro Quick Trip card, black Primo backpack, Greyhound bus ticket, and APD envelopes and voucher packaging. These were found on Luigi's person. So this is what he had on him, like in his pockets or whatever, at the time that he was arrested. Black phone charger, green tool, black gray wallet, chrome drill bits, pins with SIM card remover attached, and a roll of black duct tape were all in the black backpack that he had with him at the scene. Credit and debit cards, a brown wallet, a Maryland driver's license, a passport, and 1 APD envelope also in the backpack. Zip ties, a silver tool, a tan rubber band, a white metal knife, 2 empty Ziploc bag, and 1 APD envelope, black wired headphones, another memory device, some AAA batteries, multicolored hat, 2 pairs of boxers, 1 black face mask, 8 pairs of socks, 1 black backpack, 1 blue backpack, 1 white t-shirt, 1 light green jacket, and 1 parka jacket. Several backpacks, like in the backpack. Is this again speaking to the counter surveillance? Maybe. I don't know. I know. I will say, when I travel, I don't like to check a bag. If I don't have to. But sometimes, like you're going to be coming back with more than you took. And so it wouldn't be unheard of for me, to go like with an extra backpack in my backpack so that I could check, a backpack full of stuff on my way back or something like that. There's, I think, potentially innocent explanations for this. Again, we just don't really know what they are. Now, the 78.07 and 72 cents in U.S. currency. This goes back to the point from the first episode, which is that Luigi is a rich kid. Okay, he's got $7,800 in cash on him. Comes from a very, very wealthy family. So he's got some resources that kind of raised some questions initially about what is his real opportunity to commit this crime, given some of the details that we don't know. Like the e-bike, for example, was a big one. Is this a rented e-bike? Or did he's got the means, it seems. He could just go buy an e-bike. You can definitely buy an e-bike for less than $7,800. And of course, $7,800 is like what he's got left. I mean, they'll have his financial records, so they'll be able to trace when he went to the cash machine and so forth. But just point being, this is a rather large amount of cash, I think, for most people to be carrying around. A black marker, a flashlight, a white and blue face mask, one shoelace, all in the backpack, a black Casio watch, miscellaneous pills, 33 of them, don't know what they are, more face masks, a Polaroid camera, another pair of headphones, hair trimmer, black phone charger, nail clippers, pencil, toothbrush, pair of scissors, black keyring attachment, and tweezers, Band-Aid. And then on his person, another wallet, a blue pouch, a Chase envelope, foreign currency, and one APD envelope. All taken all together, this picture of what is in the envelope, it looks like somebody who's on the road. It looks like somebody who, you're carrying your toiletries around. You are traveling. You are expecting that you're not like going home right now. This is not just your day pack that you carry around to be able to stuff stuff in. You're preparing for at least some overnight stays. Then this is the clothing that he was wearing at the time, taken from his person at the detention facility. So his blue jeans, shirt, boxers, socks, and put that in a paper bag. So more stuff from the backpack now that's a little bit more significant. So the black firearm, the Glock magazine, 6 Luger ammo, ink 9mm cartridges, very specifically identified, the brand and type of the cartridges they found, which they did not do with the shell casings at the scene. So we don't know if they're the same or not. Might be, might not be. The black cylindrical firearm attachment wrapped in tape, which is the silencer. The magazine with some more 9mm cartridges of different types of brands and makes and so forth. Then also, more things he was wearing: his jacket, gloves, belt, beanie, leggings, jacket, shoelaces, black neck gaiter. In the backpack, also the red journal, which we heard about from the probable cause, 11 handwritten notes, 2 envelopes, paper with a handwritten note separated at the top, white miscellaneous paper. I don't know if this paper with handwritten note separated at the top is referring to the Fed letter that they described, Dear Feds, but it might be. A MacBook computer and a black Apple iPhone were in his backpack. 2 black Faraday bags. That probably speaks a little bit to some counter surveillance activity. Faraday bag is going to block the signal from your cell phone to the tower. So if you want to allow your location, to be not traceable, a possible way to do that might be to put it in a Faraday bag. More details about stuff in the backpack, computer-related things. These are like a bunch of, cards and cables and USB adapter, things like that. So now they have swabbed the firearm in the magazine. Again, we're looking for DNA. We're comparing that to the DNA at the scene. actually, no, we're not comparing it to the DNA at the scene. They don't do that. They're going to compare the DNA at the scene and the DNA that they take from these other items, both to Luigi. They're going to get a sample from Luigi, which is a known sample, and compare those to all these unknown items of evidence. Same thing with the silencer. Magazine and cartridges, the notebook, the pizza box abandonment sample. Now, this is kind of interesting. Apparently, I am to infer from this that at the Altoona Police Department, in his cell, he got some pizza in a box and he ate it and he threw the box away, and they then recovered the box and used that to do some likely preliminary testing. I say likely preliminary testing because this is the kind of thing that you've heard about if you follow like the genetic genealogy cases and how those types of things typically work. They will, get a suspect identified based on their their genealogical research, and then they will try to find once they've identified down to who they think is likely, they'll try to get these voluntary samples from the people to see if they match whatever evidence was obtained from the crime scene. And so, if people volunteer to provide it, that's great and that's helpful, but often they don't. And so not unheard of to go and pilfer some trash. But the issue with that is that you typically still have to confirm it with a known sample that you get with a search warrant from the individual, just because it's not 100% foolproof. A pizza box has been handled by multiple people. It's not sterile. You can have trace contamination issues and things like that. So it might get you in the ballpark and it might get you in the world of suspicion, but it's not going to be the strongest evidence that you have to use at trial. You're always going to get a search warrant for a swab from that individual person that comes straight from their mouth, and then there's no issue about it. Same thing with the lemonade bottle. So pizza and lemonade that he had in the cell, they grabbed them both to have them available for DNA. They don't reference any swabs for them, so maybe they just never went down the road of actually doing that testing, but just took it so that they would have it if it's available. And then finally, these laptops at Best Buy, they were display laptops. So they traced them there somehow. They're going to, claim, and got these laptops presumably because there is something helpful, something relevant. If it was just he went in and he touched a laptop and he, did like the same test kind of program, that they all have, there's really nothing significant about that. So you probably wouldn't go like take Best Buy's sample just because somebody you're interested in went and had some contact with it. It seems more likely to me that these laptops were used in a way that they think is somehow incriminating, and that's why they preserve them. But we don't know for sure. So then a few other items of tangible property, a CVS receipt that they got from the Altoona CVS. So he went to CVS. This is, the implication here. Bought something there, and they were able to recover it. How they got it, don't know. Maybe tracing his finances, maybe, again, from video surveillance. Hard to say. The hostile registration for Mark Rosario. That's going to be an important piece of evidence. A deformed fired bullet. So they recovered at least one fired bullet from a CV person. This is the crime victim. So they got a deformed fired bullet from the victim, from Brian Thompson. Does that mean it's going to be suitable for comparison? Don't know. Sometimes deformation can be accounted for. Sometimes it can't. It just depends on how bad it is. The victim's clothing worn at the time of the incident, the victim's watch, property taken from his person, currency taken from his person, his black socks, all of these things that you would recover during the autopsy. Possible bullet fragments recovered from the morgue, from the crime victim. So two things that we've got here. We've got a deformed fired bullet, and then we've got some possible bullet fragments. Sounds like, yes, he was hit a couple of times. So bullet fragments, unlikely to be suitable for comparison, especially if we can't even say for sure that they are bullet fragments. You know, they're just possible bullet fragments. Trace evidence from deformed bullet. Trace evidence. This is kind of interesting because it's not specified what it is, but trace evidence, you're usually talking about blood, you're talking about DNA, you're talking about some type of evidence like that. We would sort of expect there to be blood on it because if they found it inside the victim, it's going to have the victim's blood on it. But whether there's anything more significant to it than that, we don't know. Swab from possible blood stain on deformed bullet. Well, yeah, if that's distinct from the trace evidence, then that makes it kind of hard to know what the trace evidence is referring to here. Not necessarily clear what that is. And then just variety of personal property that was in the hotel that Brian Thompson was staying at. They're intending to do in-court identifications. They're asking for protective orders on discovery. They will disclose supplemental, and that's essentially the bulk of this document. So I wanted to go through that just to really highlight everything, all of the roads, all of the avenues that they went down to try to make this connection with Luigi. This is kind of everything you see here, particularly when you see swab. When you see swab, these are all going to be opportunities to close that circle between the shooter, Luigi, and Mark Rosario, the person using the Mark Rosario identification. So yeah, it's quite a lot more than we saw in just the original probable cause. So with that, let's go ahead and now move on to the defendant's omnibus motion. So we're going to look at both the defendant's motion and then the state's response. They're both going to explain to us what the facts are from their perspective. What are the important facts that matter for purposes of adjudicating the claims that are being raised? And so the defendant's motion is going to focus very, very heavily on the process, the approaching Luigi, what happened, potential issues with that. The prosecution's is going to focus much more on really everything else because they're kind of, the defense is trying to highlight what they think is really important, which is, alleged procedural impropriety. The prosecution is trying to highlight what they think is really important, which is ultimately, it doesn't matter. They got the right guy. So we're going to see very, very different approaches to how the evidence is presented in these two different documents. And we're not going to go super in depth into the legal arguments that they're making, but we are going to go ahead and look through them and talk about them from kind of a 10,000 foot perspective as far as what do they mean? What's the likelihood that they're going to be granted and that type of thing. So this is based on Karen Friedman, his lawyer's affirmation. Here's what he's asking for: suppressing the statements to law enforcement officers as they failed to provide him with Miranda warnings in violation of his Fifth Amendment rights, suppressing the evidence seized at the time of his arrest because law enforcement conducted a warrantless search of his backpack in violation of his Fourth Amendment rights after he was already handcuffed and surrounded by 10 police officers, precluding the district attorney's office from eliciting lay non-eyewitness identification testimony at trial. These are the three issues that are still outstanding. They are going to be what's addressed in court starting next Monday. There's a hearing set for December 1st. It's estimated to go several days. So those are the items that are on the table for that hearing. The dismissing the indictment's terrorism-related counts has already been addressed. That's been granted. They threw those out. And then dismissing the indictment because of concurrent state and federal prosecutions in violation of the Double Jeopardy Clause. That's also been addressed. That has been denied. They said you can adequately defend yourself against simultaneous prosecutions. So let's get into the bulk of what she's arguing. So she's got a good, good table of contents here that kind of lay out. You can get a little bit of perspective sometimes on what people really think their winning arguments are based on just the table of contents. Because we can see, for example, the statements to law enforcement must be suppressed because of the lack of Miranda warnings. This is only 3 pages. This is only 3 pages. There is not an extensive amount of this brief dedicated to this particular issue. The big bulk of the brief is here on the suppression of the evidence from the backpack. The eyewitness testimony is also short. The indictment is a little bit longer. And then the double jeopardy was also a little bit longer, but by a long shot, they spend the most time and attention on these issues that they are raising with respect to the backpack. And then the facts, as they're laying them out, is quite important to them as well. They're taking 12 pages to lay out their version of the facts. So let's get into what those facts are. These are just some background. She's the lawyer. She's making this statement based on her review of the documentation. So let's start with the overview. 337 people were murdered in New York City in 2024. Only one, however, the December 4th, 2024 shooting of United Healthcare CEO Brian Thompson, has led to a legal tug of war between state and federal prosecutors as they fight for who controls the fate of 26-year-old Luigi Mangione. I'm going to stop right here because while this is a rather colorful introduction, and I think the rhetorical purpose of it is pretty clear. The implication is we are treating him differently for some reason. We're singling him out for some special treatment compared to all of these other murders that happen in New York City. But I don't find this particularly persuasive legal writing because these types of appeals just don't really work on judges. They don't really work on judges. Now they might if they are really important to the point that you're making in your legal argument. If you're making a point about, for example, maybe we're moving to dismiss based on vindictive prosecution, based on selective prosecution, based on some type of government misconduct, then maybe this type of background, it's more relevant. And so it might have a little bit more power to persuade. But this motion is, focusing significantly on what police did when they first contacted him, leading up to them taking him, into custody. And it's just not real clear that has anything to do with like the simultaneous state and federal prosecutions that didn't happen until, later in the game. I just, this is not, from my standpoint, enormously skillful legal writing. It might be persuasive from a PR standpoint. And so anytime you're looking at a case that's high profile and getting a lot of attention, kind of got to have one eye on what are they doing here for the court versus what's being done for the public. This introduction to me purely for the public. This is not only not helpful to the court, but you actually run the risk that this kind of thing might be a little bit counterproductive. Because it suggests that you're trying to be a little bit manipulative. You're trying to rely on emotional types of ploys to get what you want, rather than just focusing on the merits of what happened and what your claim is, not having to color everything so much. As a result of unprecedented prosecutorial one-upmanship, Mr. Mangione now faces 3 simultaneous prosecutions in 3 different jurisdictions, one of which is seeking the death penalty, while another is seeking life imprisonment. Footnote tells us he's also facing the forgery and gun possession charges in the Commonwealth of Pennsylvania. All for one set of facts. Yet despite the gravest of consequences for Mr. Mangione, law enforcement has methodically and purposefully trampled his constitutional rights by interrogating him without Miranda warnings in violation of the Fifth Amendment and illegally searching his property without a warrant in violation of the Fourth Amendment. So this is the purported link to like the special treatment, right? The calling this out is different than all of the other murders. The problem is this is really unlikely to land because motions to suppress statements and motions to suppress evidence are going to be almost pro forma in like pretty much every murder prosecution. You're going to be looking for something. It doesn't speak to the merit of your case at all, the merit of your claim that there's been a constitutional violation here. So again, just not finding this particularly persuasive from a legal writing standpoint. Compounding these constitutional violations, the district attorney's office has expanded New York's terrorism statute well beyond its legislative intent. So we're going to skip this part because, again, that has already been addressed. So he's requesting that the court suppress his statements to law enforcement, evidence illegally recovered without a warrant from his backpack, also preclude the district attorney from eliciting lay non-eyewitness identification testimony at trial, and based on the terrorism statute and the due process arguments. So the alleged facts. Here is the defense's account of the facts of the case. On December 4th, 2024 at 6:45 a.m., United Healthcare CEO Brian Thompson was shot outside the company's annual investor conference at the New York Hilton Midtown. Mr. Thompson, who had been subject to previous threats, now this is citing to an article, died at a local hospital approximately 30 minutes later. Reason to bring this up is to suggest that there is a mistaken identity at issue, right? If there are maybe multiple people that share a motive to perpetrate harm on Mr. Thompson, that's not distinctive, even if Luigi does share this animus. It's something that other people share, and so it doesn't, it's not particularized to him. Following the shooting, the NYPD released video of the shooting and pictures of the masked suspect to the public. Within hours of the shooting, law enforcement also disseminated to the media and the public that 2 of the discharged shell casings had the words "deny" and "depose" inscribed on them, and that the word "delay" was inscribed on a bullet recovered at the scene. Now we have a footnote here that just points out that this was originally misreported what the actual words were, but then it was subsequently corrected. When they say it was inscribed on a bullet recovered at the scene, this is what I wonder, is this the trace? Is this the trace bullet, trace evidence that was recovered from the deformed bullet? Is that what this is referring to? It's not clear because people are often imprecise with their language when they're talking about things like cartridges, casings, bullets, and stuff like that. Lots of time people use bullet to mean cartridge, which is the bullet plus the casing and the primer and just all the other parts of a bullet. Those are like the main ones. So I don't know. It's not clear to me if what was inscribed, this third item that was inscribed, was a cartridge that was inscribed, or was it actually like on a bullet that was recovered? I don't know. The NYPD began a nationwide manhunt to search for the masked perpetrator and also enlisted the help of the public by posting a reward for information leading to his capture. The NYPD viewed thousands of hours of surveillance video to attempt to locate the shooter and where the shooter had been in the previous weeks. The NYPD police commissioner stated that she assigned 10 detectives from the NYPD's intelligence division to search through social media profiles of hundreds of young men who looked similar to the shooter and had also posted negative comments about the health insurance industry. And a footnote here to an article that presumably substantiates that statement by the commissioner. So again, pointing to the possibility of other perpetrators, a mistaken identity, a non-specific, non-unique motive that would be shared by lots of people who could potentially then be the shooter. On the morning of December 9th, 2024, patrolman Joseph Detwiller and Tyler Fry of the Altoona Police Department responded to a McDonald's restaurant based on a 911 call of a suspicious male that looked like the shooter from New York City. Arriving at the McDonald's, the patrolman, both in full uniform and displaying badges, approached Mr. Mangione at 9:29 a.m. as he sat in a table in the back of the restaurant. As pictured below, Mr. Mangione was sitting at a corner table with a wall behind him and to his left. And then we have another footnote telling us the still photos embedded in this motion are screenshots from the police body-worn camera footage provided to the defense by the prosecution. So now remember, when we first looked at the probable cause from the Altoona Police Department, and was like the least specific leading up to the FBI's probable cause statement, which was the most specific, most detailed. They all described the circumstances of this contact leading up to the arrest. We know now that there's body cam footage of the whole thing. And so, you can fact check. We're going to be able to fact check ultimately what both sides are saying took place at the time, because we're just, they're going to play the body cam in court. People are going to be able to see it with their own eyeballs and decide for themselves, oh, did Luigi start to shake and go quiet as soon as they said, have you been in New York lately? Like the Altoona police report suggests happened? Or does it look more like he was behaving perfectly normally, and that isn't really a report that we can confirm? Maybe suggests some exaggeration on the part of the police, if not, potentially outright fabrication. It simply didn't happen. We're going to be able to fact check that. So here's the first embedded photo from the body cam. You can see him sitting in the corner. He appears to have his laptop on his lap, working on it. Some items on the table there. Can't see much about this plastic bag, but I do wonder, is that a CVS bag? Is that maybe how we got to CVS? I don't know. Total speculation on that. But, by himself there in the back corner of the restaurant. Patrolman Detwiller and Fry positioned themselves to Mr. Mangione's right, blocking his only exit from the table, so like over here, as he was already surrounded by two walls and a table. So they're saying police came and blocked him in where he can't get anywhere unless he goes over the table. Patrolman Detwiller first asked Mr. Mangione to pull down his face mask and then asked for his name. Patrolman Detwiller told Mr. Mangione that someone had called the police because they thought he was suspicious. Both patrolmen were in uniform and fully armed. After Patrolman Detwiller asked to see Mr. Mangione's identification, Mr. Mangione is alleged to have provided a New Jersey license in the name of Mark Rosario. The patrolman asked Mr. Mangione if he was from New Jersey and whether he had been to New York recently. As Mr. Mangione prepared to eat his food, Patrolman Detwiller moved even closer to Mr. Mangione and asked him what he was doing in New York. Before Mr. Mangione even responded, Patrolman Detwiller asked him to stand up and put his hands on top of his head, with Detwiller grabbing and lifting Mr. Mangione's right wrist above his head. I'm going to pause right here because this sentence goes over the next page, but just to address some of this. So obviously a different account than we got from the Pennsylvania police. The Pennsylvania police made this very specific comment that as soon as they asked him if he had been to New York recently, he went quiet and started to shake. The defense doesn't address any of that. Now, they don't say it didn't happen, but they certainly don't mention it that it does happen. And so we just turn immediately now to Luigi preparing to eat his food and continuing to be questioned, which incidentally was not mentioned in the Pennsylvania version of events. So as far as this initial contact, the first question is going to be, okay, is there any problem with this? What about this, if anything, raises any red flags, and why is the defense presenting this the way that they are? So the general rule is that even if you're not under arrest, even if police don't have probable cause to arrest you, if they have reasonable suspicion to believe that you might be dangerous, you might be, committing a crime, or have, just committed a crime, something like that, they can detain you for a reasonable amount of time to investigate. So that's why, people can pull your car over and ask you questions and ask for your identification and stuff like that. There has to be some reasonable suspicion, but they have that from the phone call. Okay, the phone call says, I think it's this guy. So that's what they're responding to. That's what is the justification for the actions that they're taking. So they have the right to detain you for that, and to, have you identify yourself and investigate this suspicion for a reasonable amount of time. Right? They have to either dispel the suspicion and let you go, or they have to have some, ongoing continued justification to continue to detain you. So when I'm looking at this fact pattern, the fact that's really driving the permissibility of this detention is the identification, the ability to identify him. And so that's where that, providing the Mark Rosario driver's license might have been a little bit of a problem, because, for obvious reasons, as we saw, given that it was the Mark Rosario identification that was used to check into the hostel. Not smart. Don't mess up your fake name, plan by using the same fake name in multiple circumstances. It also is what ultimately ended up giving them the cause to arrest him for providing the false information to police. So nothing that I really see here is a huge problem from a legal standpoint. They're allowed to detain him, so they don't have to let him go. They don't have to, create an open pathway of invitation to let him walk up and leave. And if he tried to do that, they would probably be, legally allowed to stop him from doing that. But the reason why the defense is writing it in this way is because they are trying to emphasize the lack of freedom that he had under the situation, because that goes to the Miranda standard. When do you have to be read your Miranda rights? All the time. I would represent people. They would, we would be talking about the merits of their case, and they'd be like, yeah, they arrested me and they never even read me my Miranda rights. Isn't that a problem? No, it isn't. It isn't, because when police are required to read you your Miranda rights is when they are going to subject you to a custodial interrogation. So there's the two parts of that, the custodial part and the interrogation part. The interrogation means they are asking you questions that are intended to elicit an incriminating response. So this is one area where, there's a whole lot of litigation about what's interrogation, right? If we're just chit-chatting while you're in the car on the way to the police station, and I'm not really asking you anything, but you volunteer stuff, that's not an interrogation. It doesn't matter if you weren't Mirandized. If I'm asking you innocuous questions that are not the types of things like what's your name, that are necessarily designed to be incriminating, that's not going to be an interrogation. That's not so much what's at issue here, because they're definitely asking him questions designed to elicit incriminating information, trying to get him to admit, yeah, he was just in New York. And that, they're asking that because they're trying to connect him with the shooting in New York. The issue here is whether this questioning was custodial. And so what custodial means in the Miranda context is that it's taking place under circumstances that are associated with the like a formal arrest. The original Miranda case was based on the station house interrogation, right? You might lock somebody into the interrogation room for hours and keep them away from any human contact and food deprive them and sleep deprive them and things like that create these incredibly coercive pressures on somebody to just confess to get it over with. And so that's really the circumstance that the Miranda case was intended to prevent. So a lot of litigation then circles around, well, what does that mean? At what point is the line crossed between, I've been arrested versus I've been detained. I'm having a voluntary conversation versus, they're asking me, but I still feel free. Like there's not this association of the coercive types of circumstances and control that are particularly problematic from a coercion standpoint. That's why the defense is raising it like this. They are trying to paint this as custodial as possible. From the very first minute, he couldn't get away. The police are standing over him. They're asking him these intimidating questions. Is this a circumstance where a reasonable person would feel that they are free to leave? Probably not. And the reality is, again, he probably wasn't free to leave because they're probably doing this reasonable suspicion Terry detention of him. But they haven't put him in the cruiser, haven't taken him to the station, so where exactly is that line gonna be drawn? So they now have some physical contact, asked him to stand up, put his hands on top of his head. Officer even, contacted his hand and put it right above his head. And the police are going hands-on to you. That's pretty controlling, I would say. That's pretty much an escalation of the control that they're exercising and the extent to which they are communicating. You don't have options here. Is it lawful? Well, yeah, you get to Terry frisk people too if you have a reasonable suspicion that the person is potentially armed or dangerous. You get to do a limited frisk of their outer clothing to look for weapons or contraband. So the reasonable suspicion here is they think he might be the New York shooter. The New York shooter murdered somebody, might continue to be dangerous. So again, they probably have the legal right to do these things. The question is, does that convert them into a custodial setting such that they were required to read him his Miranda rights? Patrolman Detweiler asked Mr. Mangione why he was nervous. Why are you nervous? As Detweiler frisked Mr. Mangione, Patrolman Detweiler ordered Mr. Mangione to sit back down at the table and directed Patrolman Fry to talk to Mr. Mangione, while Detweiler motioned for Fry to move physically closer to Mangione to reinforce Mangione's inability to leave. Mr. Mangione was cooperative and complied with every request. The way that the defense is writing this makes it very much sound like they are using a good cop, bad cop type of strategy, doesn't it? We got this mean guy, Detweiler, who's just overbearing and asking all these hard questions. But then he's going to give you the opportunity to talk to this nice guy over here, right? Fry has been nice. As Patrolman Fry effectively had Mr. Mangione in custody while he stood watch over him and blocked any potential exit, Patrolman Detweiler went outside to call another officer and tell him that he was 100% sure that Mr. Mangione was the individual that law enforcement was looking for connected to the December 4, 2024 shooting in New York. Well, they have that in quotes, right? So that means it's probably on the radio or, at least in a report, maybe in a call record, something like that. So they have that quote. He was 100% sure. Why does that matter? One of the factors that goes into deciding whether somebody is in custody for purposes of Miranda or not is whether they have probable cause to arrest you at the time. And part of that is the idea that police can't just kind of jerry-rig the situation, manipulate the situation to be able to do something that they don't have the right to do had they done it differently. So like they can't just, not arrest you if they are fully intending to arrest you and planning to arrest you and in the process of arresting you, and not, be subject to the requirements associated with actually arresting you, right? That would just allow them to be able to work their way around constitutional requirements by deciding, hey, these ones don't attach until you're arrested, so I'm just not going to arrest you, and I'll do the other stuff anyway, So that's why they're bringing that up. He was 100% sure, so he's thinking, I have probable cause. Now, does he? No. No, he doesn't. Nobody cares if this cop is 100% sure. This cop is not God. And I don't know what your 100% sure is even based on. He sort of looks like him. Is that going to be it? Yeah, I don't think we're going to have probable cause to arrest him for being the New York shooter at this point in time. Patrolman Detweiler returned to the back area of the McDonald's to further interrogate Mr. Mangione and asked if he was from New Jersey, what he was doing in Altoona, and whether he had been to New York recently. Even though Patrolman Detweiler had already decided that Mr. Mangione was a New York shooter, he told Mr. Mangione, as a pretext for the police interaction, that they were there because Mr. Mangione had been at McDonald's for 40 minutes. Police are allowed to lie to you guys. They're allowed to lie. They are indeed allowed to lie. Is that a factor that converts it into a custodial setting? Not necessarily, but again, the defense here is trying to paint a total picture, okay, where like each individual thing might not be enough, but they want to give the idea that when you consider all of these things together, he might as well have been under arrest right now. It was inevitable. It was happening. And yet they're still not reading him his Miranda rights while they're asking him these questions designed to elicit, have you been an admission that is potentially incriminating? Why, yes, I was just in New York and I left on December the 4th on a bus, from the station. And I stayed at the hostel while I was there. Like, that's where this is going. Patrolman Fry remained in his strategic position, blocking Mr. Mangione's exit as Detweiler continued interrogating Mr. Mangione. And so now they're showing the picture of what this looks like. We don't have great perspective here because I can't really tell like how close to this side versus this side of the table is he. He's over here, but it doesn't really matter. The point the defense is making here is pretty much the same. He's not in a position where he can just get up and walk away from this police officer. So that makes the situation controlling and coercive. At 9:41 a.m., 12 minutes after they first approached Mr. Mangione, Patrolman Detweiler moved a backpack from the floor where Patrolman Fry had been blocking Mr. Mangione's path to an area far out of Mr. Mangione's reach. In the next minute, 5 additional uniformed and armed officers entered the back area of the McDonald's where Mr. Mangione was detained and in custody. So now, escalating from just we're blocking you to now we're also separating you from your property. So if you want to get up and leave, you either have to abandon your backpack or, you have to like figure out a way to get to it around all these police officers, a bunch more of whom who have now shown up. So you're clearly not free to leave at this point in time. Patrolman Detweiler ordered another officer to stand next to Patrolman Fry, forming an armed human wall, trapping Mr. Mangione at the back of the restaurant. as Detweiler walked outside to talk with other officers to confirm that Mr. Mangione fit the description of the New York suspect. Still in the investigation stage of this. When Patrolman Detweiler re-entered the McDonald's at 9:45, there were 3 patrolmen surrounding Mr. Mangione, and Mr. Mangione's backpack was approximately 6 feet away on a table. Notably, 2 of the patrolmen were positioned between Mr. Mangione and the backpack. Okay, this separation here between Mr. Mangione and the backpack, this is doing 2 things for the defense. One, like we've been saying, it's kind of emphasizing the custodial nature of this circumstance. He doesn't have control over his possessions anymore. He already doesn't have control over his body. They've, physically put hands on him and made him comply. So these are things that potentially trigger the Miranda requirement. But it's also going to get to the anticipated grounds for the warrantless search of this backpack. I'm not going to go too far down that road at this particular point in time, except to say that when we talked about this in the first video, one of the things that we pointed out, like where this all went terribly awry for Luigi, was using that Mark Rosario identification, because once they were able to establish this is not a legitimate identification, who are you? And he then admits he's not in fact Mark Rosario, he gave them a fake ID. They now have a basis to arrest him. And when you arrest somebody, you get to search them and any of the property that was in their immediate possession under the search incident to arrest doctrine. So part of what the defense is doing here is trying to distance Mr. Mangione from this backpack to suggest, hey, at the time that they arrested him, this backpack wasn't anywhere he could control it. They had already taken it away from him. They have officers standing between him and it. It's not necessarily going to be subject to that exception. My view, this is quite weak. And we'll talk about that why in a little bit more, but that is what the defense is doing with this particular kind of description of how things are unfolding. At 9:46 a.m., with 8 officers now on the scene, another officer asked Patrolman Detweiler if he had read Mr. Mangione his rights as required by the Supreme Court's ruling in Miranda v. Arizona. So now we have an acknowledgement of Miranda. Okay, the fact that it might be required. When Patrolman Detweiler responded that he had not, the officer told Detweiler to tell Mr. Mangione that he was under official police investigation and to read Mr. Mangione his rights. Patrolman Detweiler informed Mr. Mangione that he was under official police investigation and that he would be arrested for false ID if he gave the police a false name again. Still without reading Mr. Mangione his Miranda rights, Patrolman Detweiler continued interrogating Mr. Mangione by asking if his name was Mark Rosario, to which Mr. Mangione responded no. Here's why all of this is so important, right? Because pretty much everything that they were able to do flowed from this admission right here. No, he gave the name Mark Rosario, but he's not in fact Mark Rosario. Therefore, he gave false information. Therefore, they have grounds to arrest him. So if they were required to give him the Miranda warnings before they asked him this question, are you really? Are you really this guy? Then not only is this statement not admissible, but you have a potential fruit of the poisonous tree problem, because so much of what occurred after the fact flowed from this statement right here. But for this statement right here, not clear that they got probable cause to arrest him for anything at all. They're 100% sure he's the New York shooter, but they're not that sure because they haven't taken him into custody. Have they? They're still continuing to do their investigation, and the best that they've got is, well, he looks like the guy. Maybe. So that's why this is such an important issue, and why the defense is highlighting this so much. Because if this no is a problem, then everything that only happened because of this no is potentially a problem as well. And that's a lot of the case, really, like all of the case, right? Everything they found in the backpack, all the subsequent, searching that they did of the stuff from his backpack, him being arrested, assuming they got a search warrant for his DNA. We'd have to look at, like, what were your grounds for that? If that relied on any of this other stuff, which it almost certainly did, then that's all going to be potentially a problem. That's why this is such an important fight for the defense to be making, because this answer, that backpack, all the subsequent stuff that flowed from it, that's really the linchpin that allowed the investigation to proceed further, down the road, to give them all of those things that we looked at in the discovery filing. Patrolman Detweiler asked Mr. Mangione for his real name and his date of birth, which Mr. Mangione provided. Another officer at the scene asked Mr. Mangione twice why he lied about his name. At this time, there were 9 officers surrounding Mr. Mangione and blocking his exit from McDonald's. And at this point, now we also do have probable cause to arrest him, and in fact do ultimately arrest him for this precise crime. At 9:48 a.m., nearly 20 minutes after law enforcement first approached Mr. Mangione, preventing him from leaving, and asked him numerous interrogation questions, Patrolman Stephen Fox finally read Mr. Mangione his Miranda warnings. After informing Mr. Mangione of his constitutionally protected right to remain silent, Patrolman Fox asked Mr. Mangione if he wanted to talk to law enforcement. Mr. Mangione exercised his constitutional right to remain silent and expressed that he did not want to speak to law enforcement. Patrolman Fox told Mr. Mangione that he was not in custody at this point, despite the fact that at that moment, there were 10 officers in the back of the McDonald's where Mr. Mangione was sitting. They had already decided with 100% certainty that he was the shooter, and he was clearly in custody and not free to leave. Clear, you gotta say it's clearly, it's not clear, right? That's your argument. I never like when sometimes you do it, but it's always like a red flag when somebody says it's clearly something, because it highlights to me that it's probably not actually that clear, because you would show me the clear part about it, instead of just trying to, bash me with it's clear. I insist that it's clear. This is the disputed issue, whether he was in custody or not. Patrolman Fox then asked Mr. Mangione why he had a fake ID. After Mr. Mangione did not answer, Patrolman Fox ordered Mr. Mangione to stand and put his hands on the wall so Fox could pat him down, to which Mr. Mangione complied in all respects with these directives. So something that I notice in this, not sure that it's really like a critical issue that has been argued at this point, but they finally have gotten around to reading his Miranda rights. He has said he doesn't want to speak to law enforcement, so he's invoked. And at least that's the issue. Is this an adequate invocation? Because if this is an adequate invocation, you're supposed to stop asking him questions at that point, right? But they persisted. They persisted in asking him the questions. It's probably a no harm, no foul type of situation, because he didn't answer it. But if he had, we would be over here right now arguing about what exactly did Mr. Mangione say, because they're going to be arguing, is that an effective invocation of the Fifth Amendment? This is another one of those areas where, God, there's so many exceptions and so many situations where bad facts have made bad law, because so much of the case law in the criminal arena is justifying things that really shouldn't be justified because we really, really don't want to apply the principle in this particular situation. And so we've created these extraordinarily complex webs of exceptions and, requirements and things like that. So with respect to the invocation, it has to be unequivocal, right? Saying, I think I should be silent, probably not going to be an effective waiver of the right to remain silent. It has to it has to be like you can subsequently waive it, and so there can just, particularly with silence, there can be issues about like, sometimes not saying anything is not even an effective, invocation of your right. It's just, it all gets very complicated. Because he didn't say anything, none of that is probably going to matter. But I think the defense is still bringing this up in part to show that, like, look, they're being sketch. They're pushing the rules of what's supposed to be allowed in this situation. And so if they're doing that here, you should also go ahead and infer that that's kind of their intention all along, is to not necessarily follow the letter, the spirit of the requirements. At 9:50 a.m., approximately 90 seconds after telling Mr. Mangione that he was not in custody despite being surrounded by officers, and after he had been patted down twice, Patrolman Fox handcuffed Mr. Mangione and thoroughly searched him again. Mr. Mangione remained standing, handcuffed, and surrounded by officers as they waited for verification of his identification. So now we have the photo of that. That is definitely a lot of cops. A lot of cops back in that corner of McDonald's. A lot of cops there, isn't it? So now he's handcuffed. Now, handcuffs in and of themselves don't mean you're under arrest. It means you're detained. It means you're detained. You're not free to leave. But in and of itself, does that mean you're in a Miranda type of setting? No. It's just all part of the picture that's being drawn here. The totality of the circumstances, all of these different things converging in the same fact pattern. At 9:54 a.m., Patrolman Detweiler walked out of the McDonald's to discuss Mr. Mangione's identification with another officer. During this conversation, and without any explanation, Patrolman Detweiler covered his body-worn camera with his hand to prevent the camera from recording 20 seconds of his conversation. Just pointing out this is sketch. There's no real inference from it. It's not clearly illegal to do that. But just pointing out, why you doing that? Why you being so sketch about whatever it is that you said here when you're having this conversation about his identification? At 9:58 a.m., several officers began searching through Mr. Mangione's jacket and pockets and frisked him again. At the same time, Patrolwoman Christy Wasser and Patrolman Fox began searching through the backpack law enforcement had placed on a table out of Mr. Mangione's reach more than 17 minutes earlier. This is important because if they're going to try to say this is a search incident to arrest or some other type of search that is justified once you're under arrest, like potentially an inventory search, then at what point did we cross the Rubicon here between he's being detained and he's now under arrest? Because you can't search incident to arrest something that belongs to somebody that's not under arrest. And there's no requirement that you formally announce when the situation has changed. But there also aren't really any facts here to indicate that the situation has changed. You're still trying to verify his identification. Doesn't sound like it's come in at the point where we start doing the search. So what would trigger? What would trigger this change of circumstance between being detained and being under arrest? potentially a problem. And then they're identifying, of course, that it was, it had already been removed from him, placed out of his reach, to try to take it out of this search incident to arrest exception by suggesting he didn't have it in his immediate possession. It wasn't accessible to him so that he might be able to recover a weapon from it, or that he might be able to get to some evidence in it and destroy it. Like, I don't know, maybe swallow a SIM card or something, who knows? That's the justification for the search incident to arrest. Again, I find this kind of a little bit weak. I don't think this is going to be successful because judges are typically going to look at scenes like this as volatile. And just the fact that you've moved it does not, eliminate the risk that he would be able to get to it and get something out of it. People do fight, people do, try to escape. There's just a lot of different things that can happen there. Had they, for example, taken it away from him, taken it out of the restaurant and like put it in the trunk of one of the patrol cars, now you got a much better argument that it's not remotely feasible that he would be able to get access to that. But the problem with that, the other edge to that sword, is that once you've done that, you've now ratcheted up the formality of the control that you're exerting over him to make it look like he's under arrest. Detaining somebody doesn't necessarily give you a right to take their property away from them. So that's kind of what they got to balance. How great of the lengths are we going to secure the scene and the circumstances versus how much do we not want to be exercising arrest associated kind of control at this point in time. As part of these warrantless searches, Patrolwoman Wasser opened Mr. Mangione's backpack and fully searched the backpack, its compartments, and its contents, including closed bags that were within the backpack, while Mr. Mangione stood handcuffed and surrounded by officers who were positioned between Mr. Mangione and his backpack. So this is not a superficial search. They are going into it, and not only going into it, they are going into the things that are in it. This is a very thorough search. And so we see the picture of that, them back in the background with their hands in the backpack while Luigi is over here, all these cops around. As part of this warrantless search, Patrolman Fox retrieved a small item from inside the backpack that was enclosed in cardboard and wrapped in tape. Patrolman Fox took out his knife and sliced open the tape to find a computer chip inside. We are bringing up this fact to highlight this is an evidentiary search. This is not a search that is justified by, for example, does this guy have a gun in here? Because granted, I don't know how small this item is. It's potentially going to be visible on the body cam, but even if it's not, it's going to be in evidence, and the actual physical item itself is something that people will be able to see. But typically, if I'm thinking about a computer chip that's like wrapped in a piece of cardboard, I'm thinking something, matchbook size, maybe a little bit bigger. It's not going to hold a weapon. It's not going to hold a gun. And so any kind of safety related justification for going into this small cardboard wrapped item is going to be very hard to justify. And that's what seems to make it clear they weren't actually doing this predicated on any kind of safety consideration. They're looking for evidence. And that's really supposed to be the distinction between some of these exceptions to the search warrant requirement, and when you need a warrant to be able to go and look for evidence in somebody's possessions. The officers continued their warrantless search through Mr. Mangione's backpack at McDonald's even after he was removed from the restaurant by other officers and driven to the precinct. Okay, so by the time they're doing that, we can be pretty sure he's under arrest now. We can be pretty sure he's under arrest now. But we still don't have any kind of a time frame about, when did that happen? During this continued search at McDonald's, patrolwoman Wasser recovered a gun magazine loaded with bullets. Now realizing she had made a potentially devastating mistake by thoroughly searching the backpack of a murder suspect in a significant New York press case without a warrant, she suddenly stated that she was searching through the backpack at McDonald's to make sure there wasn't a bomb or anything in here before putting the backpack in the car. So the way that the defense has characterized this, of course, is that she's suddenly CYAing. She had the oh shit moment. I got what I was trying to do, right? I was looking for evidence. I accidentally achieved it and realized I shouldn't have done that. So instantly, have this verbal CYA. Oh, I'm just looking for a bomb. The falsity of that comment was made clear seconds later when another officer at McDonald's stated, now that we found that, i.e. the loaded magazine, let's just bring it back to the precinct. That does make it sound a lot like you're talking about an evidentiary search. Now that we found that, now that we know there's evidence in here, let's just bring it back to the precinct. One of the exceptions to the warrant requirement is the plain view exception. And so how that's going to be critical in this case is if police are lawfully where they are when they happen to come across something, they're not required to close their eyes or act like it doesn't exist. They're allowed to account for what is in plain view in the areas they have a right to be in. So if this search is already justified, if they have a legal basis for it, then even if it happens to find evidence, they get to rely on the plain view doctrine to say, we were searching it for a bomb. We were entitled to do that. We happened to find a gun. We're not required to pretend that the gun isn't there. We get to acknowledge that because it's in plain view where we had the right to be. So, a little bit of factual complexity here with that, but clearly they recognize the evidentiary value of the magazine. Suddenly not concerned about a bomb, patrolwoman Wasser placed all the items back into the backpack and stopped searching. Patrolwoman Wasser repeated her comment that she was making sure there were no bombs in the backpack, as another officer commented that, at this point, we probably need a search warrant for it. Yeah, it's probably a good idea just in general. This is one of those things where I sometimes I don't understand why you don't just get the freaking warrant in the first place. It's really not that hard. You had him, you already have the grounds to arrest him based on the based on the false statement. Surely there's probable cause to get into his backpack to look for, I don't know, real identification or something like that. You can get a warrant to get into that backpack, even if you haven't identified him definitively as the shooter. If you've got some other crime you're investigating, that there might be evidence in the backpack for that. Because then guess what? Now you get that plain view exception. Oh, we were looking for his real ID, but we happened to find this gun. So it's just, this is one of those things where it seems very nominal to me, the warrant requirement. In this day and age, you can call a judge on the phone to get a warrant. You can do these things very quickly. It's not the era where you have to run back to the police department and type up the thing on your typewriter, and have somebody run it over to the court, and maybe, it's past after hours. And so you have to hunt the judge down at the country club, or whatever. This is not that era anymore. You can literally call the judge on the phone, be like, here's what I got. And he'll say, okay, go for it. And then you do your documentation after the fact. But, they didn't. And so a lot of the Fourth Amendment litigation just comes down to this kind of after the fact justification for why you couldn't be bothered. Why didn't you do it? Why didn't you just get the warrant? Well, here's all the reasons why. Without calling for the bomb squad, evacuating the McDonald's, or even searching for a bomb, Patrolwoman Wasser placed the backpack in her police car and brought it to the precinct. The question about this, clearly trying to imply she didn't have a legitimate concern about a bomb because she didn't even look for a bomb. It might be valid, but we don't really know because we don't know how well she has already completed her search. How thoroughly. On the one hand, you're saying she did this thorough search of the backpack. Well, if she did a thorough search of the backpack, then she already knows there's not a bomb in there, So this is the kind of thing that is ultimately going to be fleshed out at these hearings next week, because these people are going to come in and testify about all of this. And so that's going to have to be fleshed out based on the facts that are presented at the hearing. Patrolwoman Wasser left McDonald's at 10:04 a.m. There is no body-worn camera footage from her for the next 11 minutes as she drives to the precinct with the backpack. At 10:16 a.m., 1 minute after arriving at the precinct, Patrolwoman Wasser continues her warrantless search of the backpack. Patrolwoman Wasser first reopened the same backpack compartment that she had started searching at the McDonald's before immediately closing that compartment and opening the front compartment of the backpack as if she was specifically looking for something. Instantly, she found a handgun in the front compartment. Whether any of this is a problem, again, just depends on that initial intrusion into it. If that was justified, then it doesn't matter because anything that she saw or sensed as a result of that is plain view. She's allowed to follow up on it. If it wasn't justified, then you kind of have a problem, proceeding potentially either way. Also, this 11 minutes of the missing body-worn camera. It's clear that the defense is just relying on the body cam footage to, describe their version of events. So this is their interpretation of it. They think it's sus. It might be. But she also might have an explanation for it. It's going to come out at the hearing. After finding the gun at the precinct, Patrolwoman Wasser again explained to another officer that she quickly searched the bag at McDonald's to make sure there were no bombs or anything. Patrolwoman Wasser did not explain why she did not seek a warrant once she had arrived at the precinct. Patrolwoman Wasser continued to search the backpack at the precinct without a warrant and recovered a silencer, a red notebook containing Mr. Mangione's personal writings, additional writings, a computer chip, an iPhone, and several USB flash drives. Over 7 hours after the warrantless search of Mr. Mangione's backpack, the Altoona Police Department finally sought a search warrant at 5:14 p.m. This warrant application sought permission to search and seize the items from Mr. Mangione's backpack that law enforcement had already searched several times and seized earlier that morning. So the implication here is that this is an attempt to sanitize what they already did. They knew that it was wrong, so they rushed to, after the fact, try to get a warrant so that they can say, well, hey, we would have gotten a warrant anyway, so we would have been able to search it, so we would have inevitably discovered it. This is another exception to the warrant requirement, the inevitable discovery. That's going to depend on the warrant application itself and what it relied on. If it relies on any tainted type of information, it's not going to fall within that exception. Inevitable discovery, independent source are two. Independent source means there's an independent legal justification for doing the search, and a warrant is often an independent source as well. But it has to be truly independent of the other underlying taint, so to speak. So that's where she's getting at with this stuff. The reason too, this is fleshing out quite a bit more the timeline of this search and discovery of information. We didn't get this level of detail anywhere close to it in any of the probable cause affidavits that we looked at. And the reason why this is important, again, this goes to the search incident to arrest justification. That is purely based on security at the scene. When you're arresting somebody, it's a highly volatile situation. They are incentivized to try to get away. They're incentivized to try to, just destroy evidence and stuff like that. So taking possession of their stuff and making sure there's nothing in there that they could use to achieve that is the justification for it. But it doesn't extend to now you've got it all the way back at the station, right? There's that danger of the imminent arrest that is dissipated. So that doesn't extend to what you're doing at the station. You're going to either have to have another justification, or you're going to have a problem here with the lack of a warrant. And the reason why the timeline, I think, is particularly important here is because now it's identified what did you recover at the scene. If you were doing a search incident to arrest at the scene, you found this magazine. You found a magazine and a computer chip, and that was it. But all of this other kind of more incriminating stuff, the gun, the silencer, the red notebook, the writings, that's all back at the scene. If you're going to be trying to rely on the search incident to arrest to justify all those, you might have a problem with that. So just different grounds for potentially justifying the search applied to different pieces of evidence in light of this timeline. Mr. Mangione was formally arrested and charged in Altoona with forgery, possession of a weapon, and tampering with records or identification, possession of an instrument of a crime for possessing a silencer, and furnishing a false identification to a law enforcement officer. On December 14, 2024, the New York County District Attorney's Office publicly announced he'd been charged with all of these things. So these are all facts that are starting to get into the other issues that have already been litigated. So I'm going to just kind of brush over them, not spend a lot of time in them. He was charged with lots of things in the indictment. The press conference, they didn't say anything about the federal case. This I'm going to bring up because we did talk about this a little bit. On December 19th, 2024, after waiving extradition to New York, Mr. Mangione was transported via procession in a fleet of over a dozen police cars and then was flown via plane and helicopter to New York City from Pennsylvania. In and of itself, transport, not really that unusual. Upon arrival, Mr. Mangione was paraded in a choreographed, highly publicized perp walk by the NYPD, the FBI, and the New York City mayor. And we looked at the photo of that last time. Yeah, so dramatic. Front page news stuff, like him in the orange, standing out in the center of the photo, flanked by, all of these law enforcement officers and the, AKs, the the guns and stuff like that. It's quite a visual of Mr. Mangione. Hard not to look at that and think, wow, dangerous guy there. Later that morning, counsel was on the way to this court for a previously arranged afternoon Supreme Court arraignment at 2:00 p.m. Remember, he's been charged by New York State at this point. They extradited him from Pennsylvania. But now, before Mr. Mangione could be brought to this court for his planned state court arraignment, the FBI unexpectedly seized custody of Mr. Mangione and brought him to the Southern District of New York, where he was charged by federal complaint filed the night before, charging Mr. Mangione with stalking, murder, and firearms offense. These charges are based on the same facts and evidence as the New York State indictment. Mr. Mangione was remanded to federal custody at the Metropolitan Detention Center in Brooklyn, where he is currently still detained. This, to me, is one of the bizarrest kind of parts of this case. And maybe that's just because, I don't practice in federal court. So I'm not real on the ins and outs of how the federal courts do things. But I have certainly represented plenty of state defendants who have federal charges going on, people who are in prison on federal detainers, things like that. So I'm pretty familiar with kind of the sharing of the defendant. Like how does that happen? How does that happen? And so typically what happens is that the jurisdiction that gets custody of him first they get to keep him and do what they want to do with him. And then if another jurisdiction, including the federal government, wants to get him for their purposes, my experience is they have to go through this thing, the Interstate Agreement on Detainers Act. And it's this process that, it's adopted in multiple states and just basically sets up this way where, say, you got somebody in state custody, the feds want to prosecute him. The feds have an arrest warrant out for him. They basically, what that means then is that the defendant is going to, continue to be held on their state case for however long that is. And then once that's up, that arrest warrant acts as a detainer. So instead of being released out into the public, the feds are notified, they come get you, and then you're brought over for that. There's also processes for you to resolve federal detainers or out-of-state detainers or whatever before that happens. Like you're charged with a state crime, you're prosecuted, you're convicted, you get a 20-year sentence, say, and you're facing prosecution in federal court where you might catch 2 years, for example, something small. So you want the opportunity to get that federal case resolved because maybe they'll run it concurrent with your state charge. You don't really want the hassle of the transfer after you're getting released on your state charge and things like that. So there's a process for you to basically demand that come and get me. Act on your detainer or drop it, basically. So all these things are written into the Interstate Agreement on Detainers Act. That's kind of how I'm familiar with these things being shared back and forth. I am really not familiar with any process where the feds can just come and take someone out of state custody and put them in federal custody. Really not familiar with that at all. Try to do some research to find out, how do you do this? How do the feds do this? Didn't come up with anything. So this might just be kind of one of these things that's only interested to the lawyer's mind. But it's very interesting to me because this seems highly unusual and just not the normal practice. So how did they pull this off? What did they do? What exactly did they do so that the feds came and scooped him up away from the state so they could, incarcerate him in the federal institution and have this simultaneous prosecution in the first place? The last, stream that we did about this, I brought up the distinction between this case and the DeAndre Brown case. DeAndre Brown is the guy who is alleged to have murdered Irina Zarutska. He was charged in North Carolina court. I forget the level, circuit court, district court, I don't remember. But he was charged in their court. And then the feds subsequently went and filed their own charge. And they, announced that they were going to do it. And it was kind of this big press event. So there is a simultaneous federal prosecution going on in that case as well. But the difference is that in that case, the federal prosecution isn't going anywhere because they're just waiting for the state case to resolve. They're not doing whatever it is that they did with Luigi to come in and grab him and proceed with it right away. So I just have questions. How'd you do this? How'd you do this? Is this legit? I don't know. I would like to try to find out more about that. So then he was produced to the court, arraigned on the pending indictment. To date, District Attorney's Office has produced more than a terabyte of information and discovery, a lot of stuff, but they've withheld additional stuff, according to the defense. And then on April 1st, the USAG directed that the Southern District of New York prosecutors seek the death penalty. So they did, filed their notice of intent, and he was arraigned in federal court. All right, that gets us through the version of the facts that the defense has presented. So clearly what we see here is really focusing on the circumstances of the initial contact, the detention, the questioning, and the arrest. That's what's important to the defense for the standpoint of establishing whether there's been a violation here, and if there has been a violation, whether there needs to be some consequence. So something needs to be suppressed, or whatever the appropriate remedy is going to be. So first, the argument about suppressing the statements because they were done without these Miranda warnings. So establishing, it's quite clear, if there is a custodial interrogation and there's no Miranda, then the statements should be suppressed. And so here is the standard that they apply under these, New York cases. It's what we talked about. 2 factors. Is it interrogation? Was he in custody? So interrogation is any questioning or actions by law enforcement that are reasonably likely to elicit an incriminating response from a suspect. So it isn't just, this is an important point they're raising. It is not just explicit questions, although we certainly have that in this case, but it's also conduct. It's also anything that they might do to try to elicit information from you. Maybe an example would be like a couple of officers chit-chatting in front of you about, oh gosh, if this guy doesn't make any statements, it's going to go so bad for him. Oh yeah, I've worked with this prosecutor before, and when he had a guy that didn't make statements, he did this. But if the guy said stuff and he just took responsibility, he just cut him a huge break. You're clearly trying to manipulate the situation to get the guy to volunteer something. So that's really what this is contemplating. So focusing first on the interrogation. In this case, when he initially approached Mr. Mangione, he already believed he was the shooter, and he was seeking to elicit an incriminating response when he asked if he had been to New York recently. I agree with that. Yeah, I think that's pretty clear. It's pretty clear you're trying to get an admission from him. The standard for when somebody is considered in custody is met here as well. The standard for assessing a suspect's custodial status is whether a reasonable person innocent of any wrongdoing would have believed that he or she was not free to leave. Would he feel free to leave? You physically grabbed his hand. You frisked him a bunch of times. You brought in a gazillion officers. You took your backpack away from him. Person reasonably going to feel free to leave? So then again, just going through these facts, block themselves, how they position, the overwhelming show of force of the number of uniformed, armed law enforcement officers showing up. Continued to question him even after someone suggested maybe a auto Mirandize this guy, but they didn't. So they're asking for a hearing. Either go ahead and suppress them all, or we should have a hearing so that we can, evaluate whether there has been a violation of the rights or not. Under that generous description of the standard, looks like it's, colorable. Definitely colorable to be raising this issue. To the extent it's probably ineffective if you're not bringing it up, in my opinion. So now moving on to the evidence recovered from his backpack, because they didn't have a warrant. So first, looking at the legal standard for warrantless searches in New York. Now, this search took place in Pennsylvania, right? And so the Pennsylvania police officers are not thinking to themselves, what's New York law? Maybe they should if they're anticipating they have a New York shooter. But, they don't know. Sometimes it makes a distinction. Sometimes it doesn't. The Fourth Amendment to the U.S. Constitution kind of provides your floor that every state has to meet at least that minimum requirement. But plenty of states will have more stringent requirements. Washington is one of them. We have our own constitutional privacy clause, and it is interpreted to be much more protective of individual rights than the federal Constitution. So the practical effect of that means that when we're litigating search and seizure issues in Washington, we're almost like never talking about the Fourth Amendment, or other than just, bare mention to kind of preserve the issue. because our own Constitution is so much more likely to get you some kind of relief for a violation. It's always kind of possible out there when you're dealing with these sorts of interstate issues. It can open up some interesting questions about what law even applies. You know, choice of law. They did the search in Pennsylvania. If it was legal under Pennsylvania law, but not legal under New York law, what would that mean? It's tricky stuff. So I just kind of point that out, not necessarily because it is a huge issue in this case, but there's always kind of the potential for that. And this is one of the reasons why, again, I don't understand why there's this like knee-jerk hostility to just getting the freaking warrant, because it takes so many potential problems off the table. Just restrain yourself, get the freaking warrant, and then you don't have to worry about any of this type of thing. But they didn't, and they rarely do. And so we end up with a lot of job security for defense lawyers. So again, now they're kind of reiterating the circumstances. Police are conducting this search even though there were no exigent circumstances. So exigent circumstances is a potential exception to the warrant requirement. We can't afford to wait. The risks of waiting significantly outweigh the privacy intrusion. So he was already in handcuffs. The backpack was on a table over 6 feet away, and he was separated. So it's not emergency. You could have gotten the warrant. The entire search of the backpack was done well after it was secured and moved far from his grabbable area. The grabbable area is going to the search incident to arrest exception. You know, if it's somewhere where he could potentially grab a gun, then for safety purposes, you need to secure that. But if it's not in that area, then you have a lot more questions about defining the scope of the safety interest versus the privacy interest. So the Fourth Amendment protects individuals from unreasonable searches and seizures. Building on the Fourth Amendment's protections, the New York Court of Appeals has ruled that all warrantless searches presumptively are unreasonable per se. And therefore, when a warrant has not been obtained, it is the people who have the burden of overcoming this presumption of unreasonableness. This is like the federal standard too. Like anytime you have a warrantless search, the burden is always going to be on the state to justify it. So this isn't really like an add-on that New York law, provides. Based on how they're writing this, however, it makes it pretty clear to me the Fourth Amendment standard is going to be the same standard as in New York. If it wasn't, they would be telling me which provision of the New York Constitution is going to govern here. And that there's going to be standards under that apply and so forth. So when they've accepted a search conducted by law enforcement incident to a lawful arrest, they must first satisfy two separate requirements. There are spatial and temporal limitations to ensure that the search is not significantly divorced in time or place from the arrest. This goes to searching at the station versus searching at the scene. Second, and equally important predicate requires the people to demonstrate the presence of exigent circumstances. This is a little bit different than how the Fourth Amendment formulation goes. So why couldn't you have just kept it away from him, gotten your warrant, gotten into it? You're going to have to show that to justify the search incident to arrest. So it applies specifically when they're searching closed containers. Closed containers meaning, like, for example, the thing that's taped closed that they cut open to find the computer chip inside. A backpack probably isn't going to constitute a closed container because it's just a zipper. If it was like locked, you have no question it's a closed container. I'm not quite sure that a zipper applies. But again, addressing the exigency, it's got to be within the defendant's immediate control or grabbable area. And the interests that justify it are safety of the public and the arresting officer and the protection of evidence from destruction or concealment. So that's what justifies it. What you do have to be consistent with those types of rationales, or it's potentially not going to be upheld. Nevertheless, because it requires exigency, a container may not be searched for a weapon or evidence if it is apparent that it is so securely fastened that the person arrested cannot quickly reach its contents, or the person arrested makes unmistakably clear that he will not seek to reach the contents, or the container is so small that it could not contain a weapon or evidence of the crime. This is probably a problem with that the small thing that they cut open, the computer chip. Again, without knowing the size, you can't say for sure, but you know, you gotta have some reason to think there might be a weapon in there. And if it's just like a flat piece of cardboard, it's potentially hard to imagine what that could be. I suppose they might say it's a straight razor blade or something like that. Could be. I don't know. It's going to depend on the size. So similarly, even a bag may not be subject to a warrantless search unless circumstances leading to it support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence located in the bag. So again, this is kind of going to just the practical realities of the situation. Is it grabbable? How big of a threat does it actually pose? When it's not in his immediate control or grabbable area, this is what they're really leaning on. You know, they already took it away from him and positioned themselves between it. He wasn't going to have the possibility of being able to get to it. So given that, you know, you already had it under control, all you needed to do was just have a little patience and take it to the station and get yourself a warrant. And then you'll have the basis to go into it. So then, you know, they're going through some of the case law and the different facts that, you know, talk about in you know, various circumstances when it's okay and when it's not. So again, there's no exigent circumstances because when they started searching the bag, he was already in handcuffs and surrounded by police officers. The bag was approximately 6 feet away. Now, 6 feet away, that seems to me to be well within lunging distance. So I had a case like this, not even really all that long ago, and it was dealing with the search incident to arrest in Washington under our Constitution. And it actually wasn't the search incident to arrest. The issue was that they did what they called a Terry frisk of a car, which is like kind of a strange idea. So the Terry frisk is what I talked about before, where they have reasonable suspicion to think you might be armed and dangerous. They can do the brief pat down of your outer clothing to look for weapons or contraband. Not allowed to like palpitate things in your pockets, stick hands in your pockets or anything like that. It's the pat down. So the search incident to arrest with the vehicles has gone through some evolution in the federal courts over the last several years. And so originally it was like totally fine. They arrest you, they haul you out of the car. But since you had recently been in the car, they could go ahead and go in and search, you know, what's like within reach of the driver's seat, basically most of the passenger compartment. But then that changed. There was a case that came down out of the Supreme Court that said, no, actually, you know, the justification is safety. So once you have the guy like in handcuffs and in custody and he's no longer in the car, that justification has gone away. So we're no longer going to allow you to do these broad searches of cars based on the search incident to arrest doctrine. So I had a situation in my case where guy is arrested. He's not arrested. I'm sorry. Guy is pulled over. He is detained for investigation. So he's removed from the car. He is, I don't recall if he was handcuffed. I don't think he was, but he was removed from the car, like, you know, 10, 15 feet away from the car. He was at a distance and he's under guard by police. And the officers still go into the car and search the car. And the justification is, well, we're doing this Terry frisk of the car. It's not a search incident to arrest. He's not under arrest. We're just, you know, searching under Terry because of the, you know, risk that he might be armed and dangerous. So when I litigated this, my point was that, like, it doesn't make a whole lot of sense that a situation where there's less suspicion allows you to do a more extensive violation of somebody's privacy. Like, there's no question that if he had been removed from the car and placed under arrest under these circumstances, the search incident to arrest of the car would not have been justified. You would have to go get a warrant. So how can it be that by not arresting him, you have greater right to go in and do the search? And so I litigated that, and the court didn't agree with me. Court didn't agree with me on that one. Their rationale was that, well, because of the fact that this is just an investigation, that means that they might actually put him back in the car when he's done. So they need to secure the safety of the car in case they release him. And to me, this is nonsensical, because it's like, but you've dispelled your suspicions if you're letting him go and putting him back in the car. And you're also taking away the incentive that he had to grab the weapon or destroy the evidence or whatever so that he can escape accountability. You're letting him go. He doesn't have that incentive anymore. So it didn't make any sense to me, but Washington Supreme Court denied cert on that one. So what are you going to do? But anyway, I don't even remember why I went down that particular little story time segue. Because part of the issue too, they didn't like this idea that, like, being 10 or 15 feet away from the car meant he couldn't like try to get into the car still. It's like it wasn't far enough, but it's not like there's a measure where it's far enough. So it always just kind of ends up being circumstance dependent on what does the court want to do in this particular situation. In this particular situation, they did not want to undo the search for my client, so they found this workaround. 6 feet, under that type of rationale, it seems pretty grabbable. It wouldn't be that unheard of to, lunge 6 feet and grab something, but I don't know. So it wasn't within his immediate control because it had been moved away. There was a human wall of officers. Nevertheless, they kept searching it, and it wasn't exigent. So once he was handcuffed and surrounded by officers, no longer the case. They cite this decision. The danger, in their view, did disappear when a person is restrained. In this situation, the defendant was locked in the police car. The jacket was on the trunk. He was separated from it. It doesn't show that any harm could have resulted from the possible presence of a weapon. So it matters, your ability to access the thing, the realistic probability of that happening matters a lot. It's just that they have a way of finding, nuances in the facts to determine, whether they're going to find there's a realistic likelihood of harm or not. And certainly no exigency once he was removed from McDonald's, brought back to the precinct. Yeah. Very hard to disagree with that, I think. Because he's now gone. He's in jail. You have the backpack totally somewhere else. This is not a search incident to arrest type of situation. So now going to searching the backpack to make sure there was no bomb inside, this post hoc excuse did not reflect any legitimate exigency. So clearly characterizing it as, oh, she came up with this after the fact, after she realized she needed to have some kind of articulable justification for doing what she did. So first, nothing about the alleged shooting in New York or law enforcement's interactions with Mr. Mangione in the McDonald's provided a reasonable basis to believe that there was a bomb in the backpack. Yeah. Shooting somebody doesn't necessarily mean they have a bomb. Where the court's likely going to have some flexibility with this is perceiving it as a politically motivated crime. And so, does that mean there is a potential risk of other forms of political violence? Maybe. I don't know. But Yeah, believing that somebody shot someone is not necessarily reasonable suspicion that somebody has a bomb. And the second, she didn't make this claim till after she'd already been searching through it. So it does sound, and then what she did after the fact, she didn't continue to look for a bomb, does make it sound a little bit ad hoc. But then they also sliced open a small taped up cardboard container too small to house a bomb as further evidence that this was a search for evidence rather than a legitimate concern about a bomb. I await the expert testimony at this hearing about how, a bomb could be like fingernail sized or something like that. I wait with great patience to hear that. Maybe they will give us that. I don't know. We'll have to see. But finally, this police theory claiming exigency without more would render all high-profile murder cases exigent by the standard, as there is always the theoretical possibility of a bomb inside a closed backpack. The slippery slope argument. Sometimes, this is powerful. Sometimes it's not. You have to be able to point to something specific to the facts of this case to justify why is suspicion of a bomb justified in this case to distinguish it from any other exactly the same, case, except for there's maybe one variable. Maybe instead of shooting a healthcare worker, the person shot their ex-wife. Does that undermine the suspicion, to think that there's a bomb in there? If you're going to say that belief that there might be a bomb there is justified. We could also see a situation where the court, looks at the police officer's statements as not necessarily requiring like a tethering to a specific threat like a bomb. People do speak colloquially, and we can recognize that. And the fact that she's like saying a bomb could just be illustrative. She's really just looking for anything that could harm, but the first thing that comes to her mind is maybe there's a bomb. So just the fact that that's what she articulated doesn't mean that's the only type of weapon or the only type of security threat that could potentially be, posed under these kinds of circumstances. So some different ways they might try to wiggle out of this, but some of these points I think are pretty solid. I don't think you're going to justify the search at the police station under an exception that requires exigent circumstances. So rather, she thought it was an illegal search. Now, another exception, nor can the search be justified as an inventory search. So an inventory search is when somebody is arrested. It is exactly what its name suggests, a search to properly catalog the contents of the item searched. So if you're going to be arrested and your property is going to be secured and held, not necessarily as evidence, but just, held in your property in the jail until you're released, they're going to go through it all and identify what everything is. And we talked about this before. They're doing that for liability reasons, because if you walk into the jail with 10,000 cash and when you're ready to get out of jail and there's only $200 there, you got a big claim against the police. And it's not really that hard for somebody to claim, I had $10,000 cash and when I got out, I only had 200. If you don't have a nice process of inventorying and documenting what somebody came in with. So it's really a CYA thing. It's not supposed to be an evidence search, but the reality is it ends up being an evidence search an awful lot of the time, because once again, you're doing your proper inventory documentation. And look, here in plain view are some drugs, a gun, a bloody knife, whatever. So it's now in plain view. They don't have to ignore it. They can seize it under a different exception. So here, the officers were not inventorying or cataloging the contents of the backpack at McDonald's. Probably not. Probably not. What they were instead doing was rummaging through the backpack looking for evidence. It's conclusory, but it doesn't seem unreasonable. It's just that that's not necessarily going to lead to it being thrown out. It must not be a ruse for a general rummaging in order to discover incriminating evidence. The policy or practice governing inventory searches should be designed to produce an inventory. So in this particular case, if they're not like writing down what they find, if they're not being like somewhat systematic about what they're doing, making it clear we're doing this for documentation, then what you did in McDonald's isn't going to probably count as that. Now, what happened back at the station could now be a little bit of a different situation. It's just gonna depend. So because the officers had no basis for their warrantless search, the recovered evidence must be suppressed. So last one here, the illegally, I think this is the last one. I don't know. We'll see when we get through it. The illegally obtained evidence is not admissible under the doctrine of inevitable discovery. Another exception we already talked about. This is, they were going to find it anyway. So the fact that they didn't, technically wait until they got to the point where they were going to be allowed to search it doesn't really matter. So New York, the Court of Appeals has established that the doctrine of inevitable discovery does not apply, whereas here the evidence sought to be suppressed is the very evidence obtained in the illegal search, because permitting its admission in evidence affects what amounts to an after-the-fact purging of the initial wrongful conduct, and it can never be claimed that a lapse of time or the occurrence of intervening events has attenuated the connection between the evidence ultimately acquired and the initial misconduct. The illegal conduct and the seizure of the evidence are one and the same. This is a far more protective doctrine than you have just under the Fourth Amendment. So what this is basically saying is that inevitable discovery might apply to things like that plain view doctrine, where, for some reason, well, I'm trying to think of how this would work. You're seizing something other than what you initially found. I don't know. I'm coming up blank on the fly here. But basically, if they do a search and they find something illegal, they aren't going to be able to justify it after the fact by saying, well, but we could have searched it anyway. We could have done this. We could have gotten a warrant. We could have done the inventory search, like whatever. New York law appears to be quite protective on that. So it dilutes the exclusionary rule. It defeats the purpose of the rule being the deterrence of police misconduct. Yeah, it definitely does. If they can just be like, well, no harm, no foul, then why would you ever bother to follow the rules? So because it's inapplicable to primary evidence, there is no basis to admit the illegally seized evidence from Mr. Mangione's backpack. You can't go back in and come up with another reason. I forgot about this because I don't necessarily consider this to be a huge issue in this case, but he has standing to challenge the illegal search of his backpack. Standing just means that you have to be the person whose rights are affected by the illegal seizure. You can't complain that police illegally searched somebody else's property and found something that incriminates you. So this is what, comes up in like, for example, we dealt with this with the investigative genetic genealogy searches and in the Koberger case, the fact that the feds were apparently deliberately and willfully going into databases that they did not have a right to be in. They were prohibited from being in, both under, the rules of the databases and the policies for doing IgG, is not something that Brian Koberger was able to challenge because it wasn't his DNA in the database that they unlawfully accessed. It was DNA of third parties, so you don't get to raise that. You don't have standing to challenge that. So they're saying that it was in his possession, it's his. So he has a reasonable expectation of privacy in it. That's pretty standard. It's not clear to me that was really in dispute at all. But yeah, if it's his backpack, then he gets to challenge. He doesn't really have a good argument to say it's not his backpack, given that it was apparently, right there with him. But this is at least an implicit admission that it's his backpack, right? If you're asserting that you have standing, you're asserting you have an interest in that item that is protectable and recognizable as under the law. And so that tends to suggest you can't come back later now and disclaim that it's your backpack. So it's, again, a little bit of a double-edged sword. You have standing to challenge the search, but you give up the argument to be able to say, well, it wasn't mine. Maybe they planted it. Maybe it was, somebody else left it there. It was just sitting there when I got there. It wasn't even mine. Of course, don't know how strong an argument like that would be anyway, but it's a practical matter. Either way, it's off the table. So that's the defense's position on these search and seizure issues. Let's go ahead now and move on to the states. As you're going to see, they have quite a different take on things. So this is his response. So first off, they're denying the factual allegations underlying both of the claims for suppression statements and the physical evidence. They don't agree with how the defense has characterized a lot of this stuff. So, post hoc rationalization and, just some of those details. So there's going to be a hearing. That's what the hearings next week are going to be focused on. You're going to call a bunch of witnesses, probably watch the body cam, talk about the motivations and justifications and so forth. The eyewitness, we're not really getting into that at this point in time. I think this is likely going to be how it's handled. Is the court's going to say it's not ripe yet? This needs to be addressed in a motion in limine, right? Basically right before trial. So it's just a kind of series of qualifications they have to look at to see if that identification is going to be allowed. So now let's look at how the state describes the evidence in the case. Now that we also know they did a whole bunch of post-arrest investigation, what did they come up with? In December 2024, Mr. Brian Thompson was the CEO of United Healthcare, UHC, a company that provides health services to tens of millions of Americans. UHC has approximately 400,000 employees, and although headquartered in Minneapolis, has offices throughout the United States. It is the largest health insurance company in the United States and the fourth largest company by market cap behind Amazon, Google, and Walmart. In addition to providing insurance to individuals and companies, UHC provides government-sponsored insurance to citizens in the form of Medicare and Medicaid. They're a massive, massive healthcare company. Mr. Thompson came to New York the first week of December 2024 to attend UHC's investor conference, which was to be held at the Hilton Hotel in Midtown Manhattan on December 4th, 2024. The yearly investor conference was announced on UHC's public website and was attended by approximately 300 institutional investors, UHC's board members, and 50 of UHC's executives. So a lot of these institutional investors are going to be folks like, hedge fund, managers and stuff like that. Yeah. Finance and big business gets like crazy, super complicated. Mr. Thompson, who was one of the presenters at the conference, was set to arrive at the Hilton Hotel before 7:00 a.m. on December 4th, 2024 to prepare for his presentation. He arrived in front of the Hilton Hotel at approximately 6:45 a.m. Defendant, dressed entirely in black and wearing a backpack, quickly crossed the street and approached Mr. Thompson from behind. Defendant drew a homemade ghost gun, which was equipped with a homemade silencer, and shot Mr. Thompson once in the back and once in the leg from point-blank range, thereby killing him. Following the shooting, defendant ran from the scene and, during his flight, dropped a blue Motorola cell phone that was later recovered and examined by law enforcement. Video surveillance from before the shooting showed defendant drinking from an Ethos water bottle and then discarding the bottle in a trash can near the shooting location. A canvass of defendant's path of flight after the shooting revealed that he had discarded the backpack he was wearing during the shooting in Central Park, which contained a black jacket and a piece of chewed gum, among other items. So first off, of course, we have a more victim-focused description of the crime itself. We start from the standpoint of Brian Thompson, what happened to him. Now we turn to Luigi. That's going to be pretty standard. So obviously, this is also conclusory, the way they're writing it. Defendant did it. Well, that's the question that the jury is going to be asked to decide, isn't it? It's not established yet, but it's clearly the state's theory, the state's version of what happened. I only bring that up just because you don't, depending on who the judge is, I don't know who the judge is. I don't know what the background of the judge is, what the thought patterns of the judge are going to be. But when I read something like this, it instantly calls out to me, oh, what you are telling me is theory. You are not necessarily telling me facts. You're telling me interpretation, because your interpretation of the facts is that Luigi did these things, but that is not yet established. And so it does somewhat cast a little bit of a different light on what it is you're telling me. I might be a little bit more skeptical about how substantiated this stuff is versus you think you're going to be able to convince a jury that this is the case. So just once again, a little bit of a critique of the writing style. It's a risk that I think a prosecutor takes when they maybe get out ahead of their skis a little bit in terms of asserting what the facts actually are. Now, again, similar kind of thing. You drop the blue Motorola cell phone, but you don't mention seeing that in the video surveillance. So it sounds like this is an interpretation of evidence. And so how strong is that going to be? Let's find out. Mr. Thompson had been shot with a 9mm semi-automatic pistol. The bullet that killed him entered the left side of the back before piercing his liver, going through his heart, and exiting the front of the left side of the chest. Although NYPD arrived within minutes and immediately summoned emergency medical services, Mr. Thompson was dead prior to EMS's arrival. Efforts to resuscitate the 50-year-old guest to our city were to no avail. Defendant did not say a word to Mr. Thompson before assassinating him, nor did the defendant take any property from Mr. Thompson, who was wearing a Rolex watch after shooting him. This is just relating to motive. It was not a robbery motive. Of those 377 murders that his attorney pointed out in her brief, got to wonder how many of them were in the course of or related to a robbery. It's not super uncommon incidents, for somebody getting seriously hurt. But that wasn't this one. Because at the very least, you would think, obvious thing, you would take the guy's watch, if not his wallet and everything else. But he took nothing, just shot him and left. For several days, numerous NYPD detectives and police officers worked around the clock to trace the shooter's movements in New York City from his arrival at the Port Authority bus terminal on November 24, 2024, until his flight on December 4, 2024. The investigation showed that at 7:47 p.m. on December 3rd, 2024, the night before the execution, defendant was walking on West 54th Street and 6th Avenue adjacent to the Hilton Hotel. He appeared to be talking on a cell phone, and as he walked down the street, Mr. Thompson walked past him in the opposite direction. This is new from the probable cause. They didn't mention anything between November 24th and December the 4th in the probable cause. So now we have more like preparation. We have like staking out kind of, seems to be, what they're saying here. It seems to be the implication. But we don't know how they identified this person as Luigi. And I'm skeptical, because you've already highlighted to me that you're telling me your theory of events. You're not telling me like what the facts are that you're relying on. So I don't know how strong this is. But it is new information. It's new allegation from what we previously knew. The next day, December 4th, 2024, the defendant left the hostel where he was staying very early in the morning, arriving by bicycle at the Hilton Hotel at around 5:50 a.m. At 5:52 a.m., the defendant entered the hotel only to exit around 6 o'clock a.m. So there may be video of this. There might be a eyewitness. There might be somebody who was working the door, working the counter, who saw this happen. Don't know. By approximately 6:22 a.m., the defendant was lying in wait across the street from the Hilton in a plaza next to the Ziegfeld Theater. Defendant waited at that location until 6:45 a.m. when he saw Mr. Thompson walking across the street near the hotel. Defendant quickly crossed the street and approached Mr. Thompson from behind, shooting him in the back from a distance of approximately 3 to 6 feet. The police recovered ballistics evidence from the crime scene. On one shell casing, den, I think that's deny, had been written in black marker. On another, depose had been written in black marker. And on a live cartridge, delay had been written in black marker. So this answers the question I had from the defense's pleading when they said a bullet. They were misusing, I think, the term bullet. They were referring to the entire cartridge. This is suggesting it's on the entire cartridge, probably written on the brass part. Don't know for sure, but it kind of makes sense. If, it's on the shell casings, then that's written on the brass part of the cartridge. So all three are probably the same. NYPD conducted an extensive video canvass entailing review of hundreds of hours of footage from cameras all over the city. The relevant footage revealed that starting on November 24th, defendant had been staying at the High New York City hostel on the Upper West Side. When he checked in, he used a fake New Jersey driver's license bearing the name Mark Rosario. Selected portions of the video and still photos compiled by NYPD were released to the media in order to help locate the shooter, and reports of the homicide received extensive media coverage nationwide. On December 9th, the defendant was arrested in Altoona, Pennsylvania after being spotted at a local McDonald's by a McDonald's employee who recognized him from television coverage about the case. When defendant was arrested, police recovered a 9mm handgun with a 3D printed receiver, the housing for the gun's main components, 2 ammunition magazines, multiple live cartridges, a homemade silencer, and a fake New Jersey ID in the name of Mark Rosario, just like the fake ID that was used at the hostel. So this is all stuff we know. I'm going to back up here to this footnote. The word den is likely meant to be deny. Now they're talking about what was written on the shell casing. So maybe this tells us a little bit about that trace evidence from a bullet recovered from a scene. If they recovered casing, that casing is going to be associated with a fired bullet. If the word den is likely meant to be deny, it maybe means that the writing extended past the brass part of the cartridge onto the actual bullet part. And if that's the case, then there's going to be some ink on the bullet. That's potentially explainable as trace evidence. So we don't know, but just kind of a possibility based on what they have been telling us. Altoona police also recovered approximately $7,800 in cash, along with some foreign currency and a passport from the defendant at the time of his arrest. In addition, at the time of his arrest in Altoona, Pennsylvania, the Altoona Police Department recovered a red notebook that the defendant used as his diary. The diary contains several entries, including 2 entries on separate dates that explained in unambiguous terms defendant's intent and motive in deliberately assassinating the CEO of the country's largest health insurance company. The entry dated August 15th, 2024 reads in pertinent part as follows. I finally feel confident about what I will do. The details are coming together, and I don't feel any doubt about whether it's right/justified. I'm glad, in a way, that I've procrastinated because it allowed me to learn more about UHC. KMD would have been an unjustified catastrophe that would be perceived mostly as sick, but more importantly, unhelpful, would do nothing to spread awareness, improve people's lives. The target is insurance. It checks every box. I want to talk about this just real briefly because of what I think it says about the shooting. KMD, I don't know what KMD stands for, and I'm not sure that anybody knows for sure what KMD stands for. I thought maybe we're talking about Kaiser. It's Kaiser, another big healthcare provider, Kaiser Medical something, I don't know. Is this an individual person? Maybe it's not real clear what that is. But what seems to be clear from this kind of description of the thought process of like refining down what the plan is that the plan simply started as doing violence. The plan started as I'm going to do violence, and it has been fleshed out and worked over to reach a point where certain forms of violence have been excluded as not right. And this one was settled upon as something that can be rationalized or justified. And I think that's important because it to me reads as a tail wagging the dog type of a situation. It isn't a situation where I learned so much about this company and this individual, and it outraged me so much that I reached the point that I decided I needed to perpetrate violence against them. It wasn't personal like that. It started from the standpoint of, I am going to inflict some violence, and now I'm just going to figure out who and how and what. And to me, that speaks to a very different motivation and a very different personality than the person who worked it out in the other direction. It reads a lot more rationalizing. I want to do this, so let me see how I can sell it and justify it. Maybe you guys disagree, but I thought that was kind of significant. On October 22nd, 2024, approximately 1.5 months before Brian Thompson's assassination, defendant again stated his motives for the assassination. Defendant wrote, 1.5 months. The investor conference is a true windfall. It embodies everything wrong with our health system, and most importantly, the message becomes self-evident. The problem with most revolutionary acts is that the message is lost on normies. For example, Ted K makes some good points on the future of humanity, but to make his point, he indiscriminately mail bombs innocents. Normies categorize him as an insane serial killer, focus on the art atrocities themselves, and dismiss his ideas. And most importantly, by committing indiscriminate atrocities, he becomes a monster, which makes his ideas those of a monster, no matter how true. He crossed the line from revolutionary anarchist to terrorist, the worst thing a person can be. Some important things in here. The one that jumps out about me, the characteristic that jumps out to me as I read this is grandiosity. Calling the people who aren't into political violence normies really suggests that like you're more enlightened, you're smarter, you see things better and more clearly than these dum-dums out there who don't think you should maybe shoot CEOs over a policy that is so much bigger and more expansive and more complicated than just that one person's participation in it. Ted Kaczynski being like your inspiration. We normies don't really appreciate the good ideas that Ted Kaczynski had because he went out and bombed people is certainly a take. It's one way to look at it. It's a, again, rather grandiose way of looking at it because it doesn't seem to recognize that perfectly rational people can look at Ted Kaczynski's writings and think to themselves, I don't agree with his perspective that technology is inherently bad. I can agree with his perspective that technology creates self-perpetuating systems that limit human freedom, but that nevertheless, within that system, human life is far superior, and the overwhelming majority of people would choose to live the technologically enhanced life than people who would choose to return to a hunter-gatherer type of lifestyle. That yes, sure, there is a certain meaning that you obtain when your whole life is focused on meeting the absolute lowest of the Maslow's hierarchy of needs. How do I feed myself? How do I not die in the cold? How do I have some shelter? That can occupy your day, and that can distract you from I don't know, more first world problems, I guess, as we might call them. But that is because you are, in fact, more likely to die an awful, painful death from something like accidentally cutting yourself with your stone tool, because you don't have penicillin or the technology to be able to administer it. So, you know, there seems to be, from my perspective, a very strong black and white thinking here that isn't capable of really recognizing that there are actually like perfectly plausible reasons to disagree with Ted Kaczynski, that we should just go ahead and like bomb the world back into the Stone Age, and then that's the good and right and ethical kind of outcome. But like, you know, only normies might have a problem with that. Very grandiose. So, but I do think he has a point that yes, the atrocities are in fact what make somebody a monster. You know, if somebody just has ideas in their head, daydreams about, you know, taking over the world or whatever, but never actually acts on it. You know, are you going to say not a monster? I don't know. It's probably some debate around the edges, but definitely less monstrous than the person who goes through with it. But somehow, you know, if it was Luigi who wrote these things, he seemed to think that that wasn't going to apply to him, that people were going to see him differently because he didn't indiscriminately, you know, bomb innocents because he shot a CEO, as if it's like a given that a CEO is not innocent. But a CEO hasn't, you know, personally killed anybody. CEO hasn't created the structure of the healthcare system, the insurance models, the requirements of policies, all of this stuff, how it all works. So I'm not sure that that perspective really lands with me. Probably clear from last time, made it pretty clear. I'm really not a fan of political violence, and it seems, yes, quite clear to me that's what this was. This was to make a statement. These writings seem to be highlighting that. This was all about a message. Wants to send a message. The whole problem with Ted Kaczynski is people lost the message through the tactics, so he's trying to refine the tactics so people will embrace the message. And then he will be the great revolutionary leader that led to what? A big reform of the healthcare system or something like that? How's that worked out? The defendant continued, "This is the problem with most militants that rebel against often real injustices. They commit an atrocity whose horror either outweighs the impact of their message or whose distance from their message prevents normies from connecting the dots. Consequently, the revolutionary idea becomes associated with extremism, incoherence, or evil, an idea that no reasonable member of society could approve of. Rather than win public support, they lose it. The revolutionary actions are actively counterproductive. There's a footnote here about Ted Kaczynski that is mainly interesting because, oh, look, they apparently found his old review of Ted Kaczynski's book on Goodreads. How they find it, how they know that it's him, well, it's probably somewhere in the electronic records would be my guess. But he gave it a good review, noting it's impossible to ignore how prescient many of his predictions about modern society turned out. And it's interesting that these companies don't care about you, your kids, your grandkids. They have zero qualms about burning down the planet for a buck. So why should we have any qualms about burning them down to survive? Violence never solved anything is a statement uttered by cowards and predators. That's his perspective. Advocating for violence back in January of 2024. Again, just I think kind of reiterates the initial goal was always violence. The who and the how, that was all going to be secondary. It was going to be basically how can we sell it? How can we justify it? Defendant went on to ask himself, so you say you want to rebel against the deadly greed-fueled health insurance cartel. Do you bomb the HQ? No, bombs equal terrorism. Such actions appear the unjustified anger of someone who simply got sick, had bad luck, and took their frustration out on the insurance industry while recklessly endangering countless employees. Not clear to me why endangering some employees is justified where others is not. But he decided that instead of carrying out a bombing, one should whack the CEO at the annual parasitic bean counter convention. It's targeted, precise, and doesn't risk innocence, as long as we assume the CEO is not an innocent. Most importantly, the point is self-evident. The point is made in the news headline, Insurance CEO Killed at Annual Investors Conference. It brings light to the event itself. A bunch of suits from JP Morgan and Morgan Stanley meeting at a fancy New York City conference to discuss growth ratios, I think they mean ratios, and MLR of a company that literally extracts human life force for money. It conveys a greedy bastard that had it coming. It might have been your goal, but I'm not sure that you really pulled that off. Really not sure that that was effectively pulled off. I'm sure some people bought that. Some people, I think, still buy that. But as far as like a majority point sufficient to actually affect any kind of meaningful change, no, it hasn't happened. Members of the public can focus on greed on the event through reasonable, acceptable discussion. Finally, the hit is a real blow to the company financials. All those analysts and institutional investors who came to be wooed by insurance execs, that opportunity is snuffed in an instant. Instead, the company becomes a hot topic, perhaps best to invest elsewhere and let that one cool off. They did, in fact, suffer a pretty steep fall off in their stock price after this incident, but it also then rose back again after that. It's very short term. These types of reactions, very short term. Otherwise, United Healthcare has largely followed the trends of the market as a whole. Photocopies of defendant's manifesto, as contained in his red notebook, are attached here too as Exhibit A. There's this footnote explaining MLR medical loss ratio. It's a comparison of how much of your premium goes towards paying medical claims compared to how much the insurer pays for administrative costs and keeps as profits. MLR. So you pay a premium. How much of that is actually covering healthcare? And that's accounting for the fact that kind of part of the purpose of healthcare is, to pool the cost of it. So it's not like I pay, $1,500 a month for my policy and all of that is going to go towards my healthcare. No, by definition, A lot of those costs are going to pay for other people's healthcare. But how much are they spending on, going to conferences and things like that, and then paying high compensation and dividends to investors and things like that. So a lot of assumptions built in here that all of that stuff is bad. That profit is bad, that executive compensation is bad, and there's certainly valid opinions about that. But that's what political debate is for. That's what public discussion and conversation and persuading people is supposed to serve that role in a free society. Forcibly imposing that type of viewpoint by way of violence, it's typically going to be a little more tyrannical, a little more, top down. Just again goes to a little bit of grandiosity about your confidence in your goals, your methods, your objectives, the consequences of them, and so forth. And there's, to me, just a lot of arrogance that inheres in a thought process like that. At the time of defendant's arrest by Altoona Police Department, his possessions also included a note addressed to the FBI that read as follows: "To the feds, I'll keep this short because I do respect what you do for our country. To save you a lengthy investigation, I state plainly I wasn't working with anyone. This was fairly trivial, some elementary social engineering." Again, with the grandiosity. Elementary social engineering. I'm going to program people's reactions. Basic CAD, a lot of patience. CAD, computer assisted design, is that footnote. That's how you 3D print things. The spiral notebook, if present, has some straggling notes and to-do lists that illuminate the gist of it. My tech is pretty locked down because I work in engineering, so probably not much info there. I do apologize for any strife or trauma, but it had to be done. Frankly, these parasites simply had it coming. A reminder, the US has the #1 most expensive healthcare system in the world, yet we rank roughly number 42 in life expectancy. There's a little bit of a fun footnote here. Ironically, defendant, an Ivy League graduate from the University of Pennsylvania, failed to comprehend that one of the causes of America's lower life expectancy is gunshot deaths. It is one of the very common causes of death of younger Americans. So when you're doing the averaging, a lot of young people dying by gunshot is going to pull the life expectancy down. So that was just a little snark there. But yes, that is what he relies on. #1 most expensive healthcare system in the world, yet we rank number 42 in life expectancy. UHC is the 5th largest company in the US by market cap. Behind only Apple, Google, Walmart. It has grown and grown, but has our life expectancy? No. The reality is that these mafiosi have simply gotten too powerful, and they continue to abuse our country for immense profit because the American public has allowed them to get away with it. Obviously, the problem is more complex, but I do not have the space, and frankly, I do not pretend to be the most qualified person to lay out the full argument. This is now a little bit of a tell. Right? This is stepping away from like the grandiosity of the idea itself, the justification behind it, but it has obviously not undermined the willingness to carry out the act, the ultimate act of taking somebody else's life based on a belief system. Even though you can't even necessarily articulate why all that well. That's some arrogance. Holy cow. But many have illuminated the corruption and greed, e.g. Rosenthal Moore, decades ago. Now, this footnote here, apparently the defendant is referring to Elizabeth Rosenthal, author of An American Sickness, a book discussing the root of American healthcare problems, and Michael Moore, whose 2007 documentary entitled Sicko provided his views on America's healthcare crisis. I find this really interesting because, of course, since that time, we had a massive overhaul of the United States healthcare system. We had Obamacare, as it's called. So it's not even like the same system. It was supposed to like fix a lot of these issues. Obviously did not. I bring this up not because I care about the politics of it or anything, but just because to me it speaks to the extent to which this is really a nuanced belief system at all. It kind of seems like it's not. He's not even qualified to lay out the full argument, but these people that talked about a pre-Obamacare healthcare system pointed out it had problems. This is not a sophisticated take on the problems with the US healthcare system. So it is not an issue of awareness at this point, but clearly power games at play. There's that clearly again. There's that clearly. Instead of showing me, you got to just berate me with it being clear. But now it's not a lawyer doing it. Evidently, I am the first to face it with such brutal honesty. Well, now we're back to the grandiosity. P.S. You can check serial numbers to verify this is all self-funded. My own ATM withdrawals. A photocopy of the defendant's confession to the FBI and whatever is attached as Exhibit B. We'll scroll through that at the end, just because the way that it looks has some significance to me in terms of understanding kind of the background and motivation and so forth. Microscopic analysis of the ballistic evidence revealed that the shell casings recovered at the scene were fired by the gun that was in the defendant's possession at the time of his arrest. Now, it didn't, almost certainly. That's the claim they always make. They make the claims of identification, right? It was this gun to the exclusion of every other gun in the universe. There is, quite substantial criticism about the scientific foundation to be able to make that type of a claim to such an extent. Supreme Court in Maryland very famously threw out this type of claim being made in Maryland courts. You cannot say that. The best that you can say that's supported by science is that it's consistent. It's consistent with the gun. So nevertheless, that's what they're going to be arguing. It's the same gun. Additionally, DNA analysis showed that the defendant's DNA was on the cell phone, ethos water bottle, knapsack, gum, and gum wrapper discarded by the shooter during his flight from the assassination. Well, that's very much not good for Luigi, because that's really closing up this circle when we had the gap between Mark Rosario, the guy that shows up downtown, Midtown Manhattan, and commits the shooting. Not the strongest part of the case. But now Luigi's DNA is all over this stuff, that the guy on video who went in and shot the CEO is seen discarding, possessing, using, etc. Yeah, that's going to be real bad. That's going to be real hard to get out of that. That's going to be tough because this is a lot of different DNA. You're going to have to come up with one hell of a contamination argument. You're going to have to identify some major problems in this lab, because this amount of testing, this is not all happening in one session in one day. Okay, so you're going to have to identify like some kind of process that is so repeatable that, it happened multiple times to contaminate what they're testing here. I can't think of really another way out of that. I really can't. So that's a pretty high bar. That's some bad evidence. That tells me, quite frankly, Luigi's getting convicted of this. He is getting convicted. Okay, this DNA evidence seals the deal. Between Mark Rosario, can tie him to the person, And that's before we even know, like, what do they have in the volume of stuff that they've gotten from the electronic devices and so forth. The DNA alone, it's getting him convicted. End of. Anybody disagree with that? Maybe you disagree. Maybe you disagree. You got a major uphill battle getting out of that. Defendant did not have, NYPD's latent print unit identified defendant's fingerprints on the Ethos water bottle and a kind candy bar wrapper that defendant discarded in a garbage can in the plaza adjacent to the Ziegfeld Theater prior to the shooting. So fingerprints, not necessarily that helpful, but it's corroboration. It's another level of corroboration. One of the things I meant to mention here too, part of the reason why this is not helpful at all, is because you have stuff that was at the scene, but then you also have the stuff that was associated with the backpack. So it really does help link all of that together. The guy that fled, the guy that left the hotel with the backpack, all of that. His DNA is on all of it. That's a problem. Defendant did not have health insurance with UHC during the period of time from 2014 to 2024. So why the grudge with UHC? It's this big picture level social type of criticism. On December 17th, 2024, a New York grand jury voted to indict defendant for all of the various charges. And so we already know about that. So let's now work through their response on the legal issues. So I'm going to skip over the terrorism stuff because we already know how that turned out. They do not agree with the state that this constitutes terrorism. The New York Supreme Court has thrown out those charges. So it doesn't really matter. I also have not seen that they have pursued any type of interlocutory appeal of that. So it's not real clear that they're gonna challenge it, gonna seek any kind of recourse. This is, as you can see, quite a bit of their argument. The double jeopardy is next. Same thing. It's already been decided. They add a little bit more procedural stuff in here. The only one I'm going to point out here, this right here. Remember, I was like, this is really weird. This is really weird about how the feds ended up with Luigi. The federal role in the instant case began on December 18, 2024, when a writ was served on NYPD to produce defendant into federal custody. Defendant was taken into custody on December 9, 2024, after having been returned from Altoona to New York City by NYPD helicopter. So a writ is an order from a federal court judge that commands something to take place. There is no record of a writ like this in the federal case. So where does this writ come from? What kind of writ is it? Normally, when you have situations where federal courts and state courts are interfacing over a criminal prosecution, you run into what is called the abstention doctrine, which those of you that followed the Karen Reed case, you might remember that. Had to do with when Karen was seeking the review by the higher courts, the federal courts, on her motion to dismiss the prosecution after she had, we had the issue with we had the hung jury, but several of the jurors came back and said, actually, we acquitted her on several of these charges. They just didn't, sign the verdict slip. And so whether that created a double jeopardy problem, she took it up to federal court, and the abstention doctrine came up in that context. And the abstention doctrine, just broadly speaking, is that federal courts typically don't interfere with ongoing state prosecutions. It's a respect thing. A state is also a sovereign under, the Republican system of government that we have. And so federal courts aren't really in the habit of going in and ordering state courts to do things with their criminally accused. So I just remain very, very curious about this writ that doesn't seem to have a record in the federal prosecution. What kind of writ is this? Really don't know. But just one little additional detail about the process there. So anyway, lots and lots and lots and lots and lots here about terrorism and the double jeopardy argument that have both already been resolved. So this is just thrown in there kind of as an aside. It's not in response to anything the defense has done, but it is sort of important that they're demanding notice of any type of psychiatric defense that the defense intends to produce. This could be psychiatric. This could be like related to an insanity type of defense, potentially. It could be related to a diminished capacity type of defense. They're saying, giving the overwhelming nature of the evidence pointing to defendant's guilt as the assassin of Brian Thompson, which is a lot of DNA evidence, kind of hard to argue with that. It would hardly be surprising if defendant filed a notice of intent to introduce a psychiatric defense. A psychiatric defense being, I did it, but I'm not legally responsible because of XYZ relating to my mental condition. So they are simply demanding that, counsel go on the record about whether that's going to be pursued or not. So here are the writings. Okay, here are the writings. And so the reason why I wanted to point this out, what stands out about them to me, is they're organized. This is not the writing of somebody who is like in a, schizophrenic, manic, delusional type of state. Those look nothing like this. This is very organized. This does not appear to be, on its face, the product of any like psychotic, type of thinking. So whatever motivated this offense, this writer is not seeming to show the types of characteristics that suggest that this is like delusional. This was reasoned. It's just a rather distorted, differently motivated form of reasoning. Somehow we scrolled through all this and let me find. Okay. Starting with the terrorism indictment. We missed the search and seizure part. I don't think they briefed that separately. This is all terrorism stuff. Okay, now the double jeopardy stuff. This is still double jeopardy. Alleging feigned concerns about publicity while the defense is fundraising off of the publicity. Well, give me a second here, because I would sure like to be able to locate where the state briefed their response. Oh, you know what? I guess they haven't. So they have not yet provided their legal justification like they haven't provided their briefing on the suppression issues. They've basically just argued that, you know, we need to have a hearing to flesh out the facts. So the state hasn't come out and like asserted, here's specifically what exception to the warrant requirement that we think, you know, we think applies, that we're going to rely on here. What it appears that they're going to do is go in and like thoroughly hash out the circumstances of the detention and the arrest, get a factual record of exactly what transpired, and then rely on that to use their, you know, to assert their justification. And it may be different ones for different things. It might be, like I said, the initial one, they might try to justify as a search incident to arrest, or you know, maybe some kind of protective, you know, safety oriented reason for it. And then the one later at the station as an inventory search, but not entirely clear. Now, see, I could swear, trying to find it because I could swear I have in fact read. But see, there's also this litigation going on in federal court. So we're looking at what's happened in the state court pleadings. We have not looked at the federal court pleadings. So I might just be confusing. I think I am. I'm confusing what the prosecution in the federal case has responded on these issues with the states. Just checking my files real quickly here to see if I can find anything I overlooked. Yeah, I think that is where we're at. We do have a federal motion to suppress, and we have a response to it. So I think that's likely what I'm thinking about. So that's a little bit interesting, just from a context sort of standpoint. If that's the situation, the prosecution hasn't like formally taken a position about what you know, what their argument is for why they say the search is okay. We're going to, you know, flesh out the facts first. Then it's highly likely, I think, they're going to rely heavily on the federal argument, the federal prosecutors' arguments on these issues, just because they're, to the extent they can, because there is quite a bit of overlap between the First Amendment stuff and the New York state law stuff. So yeah, that's what I wanted to go over today, guys. A lot of evidence that we're just now kind of getting to learn about, and it's not necessarily painting a strong picture in my mind of a super innocent guy who's been like wrongly accused of all this stuff. Looks to me like they've got a pretty strong case. They got a pretty strong basis to be saying this is him. This is him. So that does kind of then raise the question of what is the nature of the defense going to be? Is it going to be attempted nullification? Is it going to be psychiatric? If this motion to suppress is granted, let's talk about that. If the motion to suppress is granted, let's start with the statements. If the motion to suppress the statements is granted, you know, court says he was required to be under Miranda warnings at that time. So his statements, evidence you obtained only as a result of those statements, those all have to go. You've got a major problem with the case, I think. because you don't have anything beyond you approached a guy in Walmart that somebody thought looked like the New York shooter. And he gave you the Mark Rosario ID. It's thin, very, very thin, enough for probable cause, but to get you to proof beyond a reasonable doubt, I don't know how you get there. And I'm really not sure how you get to an argument that anything that followed those statements when he admitted, I'm not Mark Rosario, that's what gave rise to the arrest. You know, all of the potential justifications for the searches flow from that. So I don't know how you get to an untainted bunch of evidence there. As far as the searches themselves go, you know, it depends on the different ones that we talk about. The second one is going to be easier, I think, to justify as an inventory search. The first one is going to be easier to justify as a search incident to arrest. But, you know, kind of same thing. If either or both of those motions were granted, you got a serious problem going forward with the prosecution. So that's one possible resolution. Now you go into federal court and kind of fight the same battle. If they're not granted, then you know, now I think you're in a situation where you got a big problem. You got a big problem. I don't think he can plead guilty in state court because he's got to hold open the possibility of fighting it in federal court. Federal court's got the death penalty on the table. So it kind of you know, puts you in a very you know, there's no real other option than to just try to take the case to trial and win. And that looks like quite a challenge to me, just from what we've seen of this evidence so far. Unless you can convince them to nullify, and I just personally tend to think that's going to be quite a hard sell under the circumstances of the case. You know, the fact you need a unanimous jury of 12 people, 12 people who, like, by definition are people who can, you know, afford to not be at work and do jury duty. You almost always end up with older folks, retirees, things like that. But I don't know if you're going to sell that. So my suspicion is that we may not really get a clear picture of what the defense is going to look like until we see what happens with these motions, because they really are going to determine a lot about the direction that the case goes. And again, you know, if there's different standards, if the New York standard is a little bit more strict than the federal standard, then maybe these things get suppressed in the New York prosecution, but it's going to be a more lenient standard when they get into federal court. So they're going to have to, you know, go through the process again in a different court to see if there's going to be a basis to present all of the stuff that the prosecution says they have. So I think that for me personally, you know, it does give me a little bit better perspective on kind of what this case is about, and you know, why it is getting the attention that it is. To me, this does not seem like a situation where we have the wrong guy. It really doesn't look like that. And not impossible. You've got to wait to trial to be sure. But if the state is going to be able to deliver on all the stuff that they say they have, this is not going to be hard to draw that conclusion. But yeah, it does seem to be a situation where there might be some cause for concern about the process. And, you know, maybe a little bit of irony there that, you know, if the motivation for this crime was this systemic issue with healthcare and the delivery of healthcare and denial of service and all of that type of thing, not necessarily sure that that landed. But these issues, these problems with warrants, and just why the hell don't you just get a warrant? Why don't you just meet that constitutional minimum? They just don't. And that's also systemic. That is an issue that is everywhere all the time, that they just can't, for whatever reason, they just can't. And maybe most of the time it works out for them, because they can point to a justification. They can convince a judge this justification applies here. But there are circumstances where they don't. And so it makes it such a high risk situation to just like operate from the default that we don't have to get a warrant and we'll go ahead and try to justify it later. I don't mean high risk in the sense that like the likelihood of it happening all the time is really all that great, but the magnitude of it can be real significant, because you can lose your ability to prosecute a whole case, even when kind of looks like you probably maybe got the right guy. At the very least, you got a real strong chance that he's going to be found guilty at trial, but you couldn't follow the process. You just couldn't do it clean. You couldn't do it clean. I don't know what the issue is. Why there is this culture of not having to run a clean investigation and the expectation that it's all going to work out, you know, anyway. So maybe like that's part of the greater meaning of this case here, as far as systemic critiques go. That like, yeah, that is part of the society that we have. We have rules. Rules have to be enforceable. There has to be consequences when they aren't followed. And everybody, especially people that are guilty, are entitled to the protections of those laws. That's why we have them. We don't have them so much to protect innocent people. I mean, we kind of do, you know, some of them, but but a lot of them is just to protect all of us. If you have, you know, sympathy for the people that the rule applies to, you're way less likely to need a rule in the first place. It's because there are people that do bad things that you need to have a rule. So anyway, guys, that's really what I got for the background of Luigi at this point. So we have the hearing coming up next week. All I know about it is that it starts on December 1st and it is scheduled to go several days. How many? Not clear. Several. There has been an order that came down in the federal court for him to have civilian clothing made available to him. So 3 shirts, does that tell us 3 days? I don't know. Maybe implies it. Not entirely clear, but anticipating, you know, multi-day stuff. I have not seen any indication about whether this is going to be televised or not. There have been televised hearings in the case, which is a little bit unusual for New York State Court, but there is some precedent for it in this case, so it is possible that that'll happen, and you know, people can watch it for themselves. But it's really not entirely clear what we're going to be able to see and how good our basis of information is going to be. So probably have to keep our eyes open for that. I will just tell you, go ahead and put it out there. I'm planning to go to New York. I don't know if I'm going to be able to get in. Don't necessarily have massively high hopes for that. but I'm going to give it a shot. You know, if it's televised, then it's less important whether I get in or not. We can just live stream it. You know, I can live stream from New York as easily as I can live stream. Well, maybe not quite as easily, but you know, it's doable. I won't like have my fancy lights and everything probably, but you know, it's not impossible. But if it turns out we don't get to see it on TV, then it's going to be one of those situations where, yeah, there's going to be some important stuff coming out at this hearing, because this could be dispositive about the prosecution going forward or not. So the details are going to matter. It's going to be one of those where the details are going to potentially be critical. So I'm going to go see what I can see, give it a shot, and just probably play it by ear a little bit. So with that, guys, we are coming up on a long holiday weekend here in the United States. Hope all of you guys are going to get to enjoy some time with your families, your friends, your loved ones. You know, the people that matter to us can be all kinds of different, you know, configurations and stuff like that. Obviously, sometimes the people that you're born to are not necessarily the people that's best for you to be around. And so sometimes this time of year can be difficult for people who don't necessarily have the most supportive kind of family, you know, that we all might like to hope that we have. But even without a bio family, if that's, you know, your situation, I do hope that you have some connections, some folks you can reach out to, friends, colleagues, anybody really, just so that you don't have to be alone. You don't have to feel like you're alone, like you're isolated or anything like that. It's going to be a very difficult time of year for people who are a little bit more isolated. So I would encourage also any of you who know people in this type of situation, don't be afraid to reach out. Just make sure that the people that you know and care about know that they are loved and cared about by you. So guys, with that, I'm going to go ahead and wrap this one up. Thank you all for joining me. I really do appreciate you kind of working through this case with me, getting to know it a little bit more intimately as far as the details of what's there. And getting us a little bit of grounding for what is still to come, this imminent motion on the horizon, and the potential downstream effects that might have. So thank you all. I do have a couple of comments here in the queue I don't want to forget about. Lawn's in order. Hey, AB. Hey, chat. Missed y'all. Happy Turkey Days. Happy Turkey Days to you too. And then we have Romy in Massachusetts became a member. Welcome. Welcome back to the channel, Romy. So that's all we got for today, guys. Take care of yourselves. Take care of the people that you care about. Try not to, you know, find yourself in that afternoon food coma on Thursday. Although, you know, if you do, it's not necessarily the end of the world. It's not the worst tradition that people can have. That little nap on the couch during the football is, you know, is a fine tradition that's shared by many of us. So do what it is that you do. Reach out to those that you reach out to. Support those that you care about. And with that, guys, I will plan to see you the next time. Thank you again, and take care.